morning. Good morning, everyone. My friends. Feels so weird not to be spending every morning with you. The very early hour of usually 8:30 a.m. Well, I guess it's not early for some people, but I'm not a morning person. Although I've become a morning person since we started handling this case together and watching the trial together of Karen Reed. Today is Wednesday, July 3rd, 2024. And we haven't had a chance to debrief on this case since the mistrial happened on Monday. Today's Wednesday. And yesterday, I needed to unplug and spend a day at the ocean, at the beach with the waves and the quiet, and unplug and go to a place where there was no internet access so that I could just decompress for a full day and not do any shows and not appear on anybody else's show. And it was something that was greatly missed. I'm wondering if you missed me yesterday, but here we are. We are here together again today because we have a routine and we might as well stick to it for a little while until we pick up another trial to watch. But so many things have happened since the mistrial. Mark Betterow and I covered it for you Monday. Most of the day he was with me. And he's on trial. Somebody asked me if he was coming in today, but he's on trial. He's not retired yet. So he's still in court. He's on trial. And I love that you love him and I love him too. But today it's me and maybe a special guest if she's able to join. So we're going to see if she's able to come on, but I know you love her too. So what have y'all been doing? What's been happening out there in YouTube world? Good morning. 4 a.m. in the UK. Oh, 4 p.m. Sorry. 4 p.m. Thank you. Somebody sent me an email and said, could you please do some more early morning shows for your friends in the UK? Because if you go live at, 8 p.m., it's too late for us and we're asleep. So I'm here for it. I am here for it. Did anybody get a good night's sleep yesterday? Because I know a lot of you. Good morning, Kim. Good morning, lady. Thanks for loving my introduction. It's a little Zydeco music that YouTube has that we have the option to use if we license it, which I did. And I love it. Makes me happy. It reminds me of Little Feat. And I think in song lyrics. And in fact, we made an entire playlist for the Karen Reed show. 5 p.m. in Sweden, 5 p.m. in Netherlands. See, you guys are coming in worldwide. The world is watching. The world is watching. I think Jackson is going to absolutely be there for a retrial. Who says he's not? Somebody said if he can't be there for a retrial, that Mark Betterow would be the next best thing. There's no reason for Alan Jackson to step away from this case. He's absolutely going to be there. We ain't got no quit, right? That's what he said. We ain't got no quit. Oh, it's 1 a.m. in Australia. Sorry, you guys, but I'm glad that you stayed up to listen to me. Thank you so much. So Proctor's state car and his gun and his gear was taken away after the mistrial, of course, because, wouldn't look so good if they did that in the middle of the trial, because then the defense could use it against them. But he ain't got no quit. Sunshine Cheryl, you are correct. He ain't got no quit. Good morning to California. Why would they even retry, Robbie? A lot of reasons. Ego, public outcry. A lot of reasons. We don't know what the split was yet, right? None of the jurors have spoken out except for juror number 3, who was chosen as an alternate, and she was very sad to be chosen as an alternate. She really wanted to deliberate, and she did not. So good morning. Good morning to Marjan in California. So this was updated just about 3 hours ago. Today's July 3rd, but this is a print story from yesterday's. What station is this? Boston 10, we were using Boston 10 for some of our live streaming because they had good audio. And they were usually right on top of the timing. Court TV was a little bit behind on their streaming. So if people were watching on Court TV in another chat, they would sometimes come in and mistakenly give spoilers. But here it is. Proctor's state car, gun, and gear was taken away mid-investigation. Massachusetts State Police say Trooper Michael Proctor, lead investigator in the Karen Reed case, has been relieved of duty and transferred away from the Norfolk County District Attorney's Office. Well, They rehomed him, my friends. They rehomed him. They didn't exactly fire him because there are a lot of hoops they need to jump through before they can fire him with, union rules and such. And they have a very powerful union, as you know. And thank you, Maureen, Francis, and Justin for getting in here with the Cash Apps this morning. Love you guys. They should just sponsor today's show. Every time they send me Cash Apps before I even go live. And look how they call him lead investigator again in the title, which we know he was demoted during the course of this trial from lead investigator to, I don't know, what do they call him? A case officer, case manager, help desk guy. They tried so hard to distance themselves from him. But in the end, he did testify abysmally, by the way, as you know, because you were here watching it with me. Well, since they are going to force us to watch this video anyway, why don't we watch it? We'll take a look. This was news at 6. I guess this was from last night. Let's take a look.
Also at 6, more fallout in the Karen Reed mistrial. Today, the governor and the head of the state police weighed in on Trooper Michael Proctor. He is the lead investigator in the case who has now been relieved of
Again, they're calling him lead investigator all of a sudden. Okay.
duty. He also drew pretty heavy criticism after his testimony revealed a series of vulgar texts he sent about Reed. We have team coverage for you tonight at 6. We want to begin with NBC 10 investigator Kathy Curran. She's joining us in the newsroom with what the governor and state police had to say about Trooper Proctor. Kathy.
Well, Priscilla, Proctor has been relieved of his duties while the internal investigation into his conduct continues. That means he's not actively working. He's still a member of the department and getting paid, but that could very well change.
Yeah, so there's that. He still gets paid. Yep, get off my lawn, Kev. We're going to show that clip next. Thanks. Kev C says, get off my lawn. Yeah, who's never cracker now? I'll show you. All right, so Governor Healy, state police, had condemned Trooper Proctor. Is this Colonel Mon? All right, let's see what they say in their little presser.
In any way, shape, or form of the Massachusetts State Police will not be tolerated.
Massachusetts State Police Colonel Jack Mon taking a strong stance against the actions of Trooper Michael Proctor during his investigation of Karen Reed, who's accused of hitting her former boyfriend, John O'Keefe, with her car and killing him. Proctor sent vulgar and demeaning texts about Reed to his family, friends, and fellow
Hold on, I got to stop that to see which picture they showed of the car.
troopers. To his family, friends, and of hitting her former boyfriend, John O'Keefe, with her car and
Oh, yes. After the taillight broke apart into a million pieces when they were trying to remove it, right? Won't look.
killing him. Proctor sent vulgar and demeaning texts about Reed to his family, friends, and fellow troopers.
She's a whack job.
I condemn those comments in the strongest terms possible.
Testimony revealed the detective was also familiar with several of the witnesses. The case ended in a mistrial, and for this trooper, a fall from grace.
Trooper Proctor, Kathy Curran from NBC 10. We'd like to ask.
Here it is. Here it is. Kathy Curran from NBC 10 goes to Proctor's house, okay, to get comment from him. He's walking up his driveway, and watch what his wife is wearing. Lizzie Proctor, who so many of you have sent me emails about things that she did to maybe terrorize people that were talking about her family online. But watch this closely. I don't like the way when I pause it, they miscolor it so I can't see. You can't look at it up close, but watch what happens here.
Trooper, a fall from grace.
Trooper Proctor, Kathy Curran from NBC 10. We'd like to ask you some questions. Do you think your actions impacted?
Is his wife wearing a pink t-shirt? Is she wearing a pink t-shirt? I think she is.
The outcome of the trial?
Get off your lawn.
I'm not on your lawn. I'm on the street.
Proctor graduated from the State Police Academy in 2014 and moved on to work as a detective in the Norfolk County District Attorney's Office. Last year, he was paid $146,000, almost $37,000 in overtime. But Proctor's fate with the department will be determined by an internal investigation and the state's Post Commission, which oversees police misconduct. Sources tell us Proctor is also part of a federal probe looking into the handling hearing of the Reed case.
Should he be fired?
This was the right move to remove him. There is a process, so we have to wait for that process to go forward.
Proctor's behavior.
So apparently your governor thinks he should be fired, but as I said, and as she said, there are certain procedures that need to be followed, hearings, etc., before they can actually fire him or suspend him without pay or such things as that.
You're the latest of a long trail of scandals within Massachusetts State Police, eroding public trust. Troopers accused of taking bribes for commercial driver's licenses. Others convicted of stealing overtime for shifts they never worked, and many more.
I did a whole show on the commercial driver's licenses issue. Go back and look for that in the playlist. Very interesting. Massachusetts State Police troopers were trading commercial driver's licenses, which, by the way, you need to drive an 18-wheeler, to companies' employees who would give them free driveways, plunge pools, mailboxes, free expensive bottled water for their station house or barracks or wherever they work out of. And they were all brought up on charges by Josh Levy, who happened to also be the acting U.S. attorney from the Department of Justice for the Karen Reed case. And this happened while the Reed case was pending. So Josh Levy is not letting go of things. And go back and watch that show. It's really interesting. I think somebody else, I think Turtle Boy might have covered that overtime scandal. I was not privy to that, or was not covering Karen Reed when that happened, but another issue.
Colonel, how can you earn the public's trust when it just seems like there's scandal after scandal after scandal?
We need to work very hard to engage the public in a more meaningful way so that we can understand what it is that we need to do and where we want to go in order to maintain trust, build trust, and in some cases regain it.
And we asked about any action being taken against Proctor's supervisors. The colonel said they're continuing to investigate. Trooper Proctor will have a hearing to determine his work status during the internal affairs investigation. His car, gun, and gear have been taken away, which is standard practice. We reached out to Proctor's lawyer, but never heard back. Kathy Curran, NBC 10 investigators.
Kathy, thank you. And this afternoon,
Oops. Cut it off too soon. Hold on. They have the union statement on here.
a statement about the trial and Trooper Proctor. It reads in part, quote, "It is our understanding that this discipline came as a result of the troopers' private text message exchanges that were made public during the trial. We also understand that it has no relationship to salacious allegations of cover-ups, collusion, or conspiracies offered by the defense." It goes on to say, quote, "We must be clear that we do not condone the language used in the text messages presented as evidence during the trial."
Wow. So the union is coming out, the State Police Association of Massachusetts, and saying, we understand this is solely because of those horrific what word did they use? Hold on a second. Text messages that he sent, and nothing to do with his shoddy investigation and his close personal ties to the people involved in this case that he was interviewing and investigating, and the fact that within 16 hours of this finding of Officer John O'Keefe's body, he decided that he was going to pin it on the girl. Wow. So it's just the language in the text messages. Hold on. Let's hear that again.
Just allegations of cover-ups, collusion, or conspiracy to select exchanges as a result of trial and
10 investigators.
All right, here we go.
Kathy, thank you. And this afternoon, the union representing the state
the
police
union
released
statement.
a statement about the trial and Trooper Proctor. It reads in part, quote, "It is our understanding that this discipline came as a result of the troopers' private text message exchanges that were made public during the trial.
Private.
We also understand that it has no relationship to salacious allegations of cover-ups, collusion."
His private text messages. Because, as the union, we didn't think that the FBI would ever get a hold of his private cell phone records and his personal cell phone records, which all of these salacious or, horrible text messages came from his personal cell phone. But, that's what we understand I can't even say that he was transferred. He was just sort of, I don't even know if he's on desk duty. They just have him in purgatory. He's in purgatory or limbo right now until they jump through the hoops of getting him either suspended with pay, suspended without pay, put on a desk. It's very vague about what they're doing about him. Yeah, we don't condone the language used in his personal private text messages, but it has nothing to do with any allegations of cover up, collusion, or conspiracies offered by the defense. I mean, is that what the union has to say on his behalf? Yeah, paid vacation, exactly.
Or conspiracies offered by the defense. It goes on to say, quote, "We must be clear that we do not condone the language used in the text messages presented as evidence during the trial."
Well, we'd
unquote.
hope not.
Now, many are wondering, what would a second Karen Reed trial look like? Our team coverage continues with Kirsten Glavin. She's live in Dedham tonight with some insight into that. Good evening, Kirsten.
Good evening, Glenn. We've been speaking with legal experts, asking some of the bigger questions. For example, would Trooper Proctor have to testify in a retrial? And to that question, the answer was most likely. All eyes on what's next as the first Karen Reed murder trial comes to a close with a retrial now on the horizon.
I think they have a lot at stake here, reputationally, to continue forward with this prosecution.
The Norfolk District Attorney's Office announcing they will move forward prosecuting this case again. Law experts say they could also change which charges Reed will face.
I could see, for example, maybe them deciding not to go forward with the second-degree murder, just the other two charges, if they thought that would help their chances of getting a conviction or make it an easier, clean.
He didn't get hit by a car. He didn't get hit by a car. I hear what you're saying. And yeah, maybe they would take the murder off the table, but the evidence showed, the credible evidence by two very highly regarded, well-trained accident reconstructionists paid by the FBI, not the defense, with biomechanical engineering PhDs. John O'Keefe was not hit by a car and a car did not hit John O'Keefe. And if a jury found that a car did not hit John O'Keefe, none of the charges would stick.
Trial.
Experts say state prosecutors will also likely have a tighter, cleaner case, knowing exactly what to expect from Reed's defense with time to prepare.
There may be a different approach to trying the case, so perhaps there'll be much.
That's Peter Ellikin. I love him. I love him. He was on Court TV with me, I think, a couple of times, some other panels. He's a criminal defense attorney out of Boston. He's very smart and he gets it. And I don't like how they don't put the people that they choose to put as experts on there. They don't put their name underneath them. So I'm telling you who he is. His name's Peter Ellikin. If you need a criminal defense attorney in Boston, check him out. I think his last name is Elliken.
Fewer witnesses, or they'll be in a different organization.
But will any of it make a difference? Some factors are guaranteed, like sky-high costs and unwavering public interest. But at the end of the day, the biggest change will be the jury.
Every jury is different. They're just of average people from all walks of life. And you never know what the makeup's going to be or what their personalities are going to be. And that's why there's always a chance of getting a different result when you retry a case and with just a totally different cast of characters.
Now, there is a status hearing scheduled for July 22nd, where both the defense and prosecution will sit down with the judge, look at schedules, and determine what's next. We're live here in Dedham tonight. I'm Kirsten Glavin, NBC 10 Boston.
Kirsten, thank you. Stay with us for the latest on the fallout from yesterday's mistrial. JC Monahan and I will bring you another episode of Canton Confidential.
The fallout is massive. Well, they waited at least until the verdict. So what? So if she was convicted, they wouldn't have done anything about Proctor? What say you? I find that interesting. Tara says, I just don't see how they can get an untainted jury the second time around. Agreed. It is right. No, here's how you spell his name. It's Elikann. I just Googled it. So thank you, Peter Ellikin. Elikann. He's great. Love that guy. He's very busy too. So he's a practicing attorney. So I try and get him on the show, but he's very busy, just like Mark Betterow. Although Mark Betterow did make a lot of time for us. Oh, Siren, I go by this too. I tell my kids this too. My mama always told me that nothing good happens after midnight. And now that your life hangs in the balance of people with room temperature IQs, I'm gonna be a hermit. It's crazy. Thank you, Anne. Many citizens had their texts illegally doxxed by Tully and Proctor. I wrote to Josh Levy looking for answers. Many civil rights violated. Thank you, Anne, for your super chat and for sharing your thoughts. Teresa Coelho is outraged and says, I've been amazing. And thanks for being a member for 2 months. Margaret, thank you for becoming a member. Just Linda, if Karen Reed was found guilty, would they still have done this to Proctor? That's exactly great minds, right? Just Linda. That's what I'm saying. Daria gifted a membership. Congratulations to whoever was randomly selected by YouTube. Rich the Italian plumber says, I hope it was worth it to protect the McAlberts. Guy threw his career away. What a moron. I mean, do you think perhaps he may have a reason now to talk? I don't know. I don't know. But you're right. Lizzie Proctor in that same clip, they cut it out, turned around and said Karen Reed is a effing murderer. I think she said effing. I don't want to misquote her at all. So I think that's what she said. You guys can let me know. Lori Life 360 for the win gives it 10 memberships. Thank you, Lori. You're so, so kind and generous and amazing. You know, they took away his gun and badge, but not Kevin Alberts, who apparently lost his gun and badge that night. He was out drinking with, who was he out drinking with that night? We saw so much testimony that now, who was Kevin Albert out drinking with that night that he lost his gun and badge? Was it Higgins? Was it Proctor? Tell me. She said, get the F off my lawn. Karen Reed is a murderer. Right. Bruce Proctor? Yeah. So Kevin Albert and Proctor were out drinking on the Cape, right? Hammered. And some of Proctor's text messages revealed from Kevin Albert saying to Proctor, dude, did you find my gun? Like, dude, where's my car? Dude, where's my gun? Dude, where's my badge? And he's like, no, but I found your badge in my car. So I don't know what that's about. Is Kevin Albert still a Canton police officer? I know you guys know a lot more than I have. Not Broken Baker. Hello to Denmark. Thank you for your super chat. You're so sweet. Proctor is just the tip of the iceberg. Bad culture in all the MSP. Yeah, I agree. I think it goes way, way deeper than the Karen Reed case. And I think that the FBI was investigating something else. And this is a collateral issue of what they were investigating. And they felt, as Josh Levy said, Josh Levy, I'm sorry, pronounces it Levy, like Eugene Levy from, all the shows. And very funny guy. And Dan Levy is his son. Eugene Levy said to both sides during a conference call, in good conscience, we cannot allow this case to go to trial. So we are working through the 2E process to give you the investigative materials that we have found during our investigation. And they did give them, in addition to Proctor's personal text messages, all of the ARCA reports and all of the other investigative material that the FBI thought, or the DOJ, the U.S. Attorney's Office thought would absolutely preclude a conviction. But in this case, we don't know how many jurors who thought that the standard of beyond a reasonable doubt was proven, and then some who didn't. Whoever wrote that note, my guess is that it's an attorney that wrote the note. And because it just sounded like there was legalese in it and made it sound like there was more than one juror who was leaning guilty and more than one juror that was leaning not guilty. So we won't know until if and when somebody speaks out. But Broken Baker, thank you for your email the other day. I didn't even see it. I took a break from this case and from the internet and from the YouTube for a while. I just needed to, but we'll do another show sometime. Sorry, I didn't see it in time. Christine, thanks for letting me be here. Absolutely, Christine. We are so happy that you're here and that you're a member for 6 months. And we already covered that. Thank you, Robert. Says Sean McDonough and News Nation report the jury was tossing murder charge and was 6-6 on sub charges. Can you comment? Doesn't that change things? That was, I don't think Sean said it was 6-6. I think there was, don't believe everything you read on Twitter, you guys. It's a cesspool. It's an absolute cesspool. Somebody cut and pasted a tweet from a different case and reported it as fact in this case, and it's not fact. So it is, I can comment and tell you that I don't think that's true, and that I don't think that Sean McDonough said that. I think it was somebody else who tweeted that. So there's been absolutely zero evidence of that, just like there's zero evidence of this video that's floating around of Karen Reed and Alan Jackson canoodling, according to the New York Post, that it's even real. AI is a deep fake. Okay. And that's why it's being legislated like crazy right now. And so it doesn't change things in my mind because I don't believe the source of that information. On civil law, new trial equals more Trooper Paul hype. Are you excited for more Trooper Paul on civil, or do you think they might try and find a real accident reconstructionist who would spout their theory? I don't think they could find one. I think they probably looked, but I don't think they could find one. And because it was ridiculous, quite frankly. There are no bumper marks on Officer John O'Keefe's body. I don't care how you feel about the 227 search. I don't care how you feel about all the other people who were in that house. I don't care how you feel about Karen Reed and her facial expressions and her alleged confession, I hit him, which, by the way, so many of those witnesses just for the first time on the stand said that. And if you have not seen the videos by a new YouTuber, his name is Sergio Denaro. I did send him an email this morning to see if he would let me play some of his stuff on the air, because I do not swipe other creators' content to show unless I have permission. He has done some work, I think. I don't know if he was with the FBI or the CIA, but he does interrogations. That's his thing. And he talks about language that people use. And he dissected this morning Jen McCabe's testimony at the request of Brian from LTL True Crime. He said on his video. And it is very, very interesting. He tells you things like whenever a witness says the word never, they're lying. Whenever they say something like absolutely never, it's a double lie. Whenever they repeat a pronoun, like Higgins would say, I, that's a lie. They're distancing themselves or whatever. I don't want to misquote him, but it is really interesting, really telling. I don't know if that science can be used in a courtroom as an expert. I just don't know. The rules in Massachusetts are, like, in many ways backwards and just so different from any other jurisdiction. But his videos are really interesting. If he responds to me while we're live and he allows me to play some of his video, I will. But go look for it later. Don't go now. And I'll shout him out in a little bit. But we have a lot to get to. Jen, thanks for coming in from Canada. I wonder why John's family is so convinced she's guilty even after sitting through that trial. What do you think, Melanie? I've heard a lot of things. I've heard a lot of things like, certain people involved in this case have swooped in from day one and grabbed their ear and have tried to convince them that Karen is guilty, to perhaps move some, I don't know, public outcry away from themselves. Hi, Elaine. I do not have the union's full statement, but I will look. FBI are working all over the state, multi-jurisdictions. We have an amazing special guest for you right now, and she's backstage. Just give me the thumbs up when you're ready, girl. Welcome, my friends. Attorney Allison Motta from Defense Diaries is coming in to give us her thoughts.
Hi, Melanie.
How are you today?
Good. How are you? It's been crazy, huh?
I know. I had to take a day off and go to the beach and sit by the ocean and turn off my phone and just take a step back from this.
Oh, I'm so jealous. That's my happiest place is the beach for sure. But now I live by a giant lake, so the beach is not the same.
Oh, no ocean, no waves, right?
Right.
I mean, I love the waves. They're just very relaxing. Where do we even start with this? Where do we even start?
I'm just, I'm shocked. And there's been I'm pretty sure. Oh, sorry. I didn't realize I didn't have so I'm pretty sure that I suspect that Judge Bev told the jurors, I can't force you not to talk. You're open. You're willing. You can do whatever you want, but I'm just going to tell you there's been a mistrial. There could be a retrial. And if you do decide to talk, it could jeopardize our chances of getting an impartial jury the second time.
That's interesting because she did say before, when she excused them, she said, I'm not going to make you guys do this anymore. I'm going to let you go. She said, I'll be in to talk to you in a minute privately. So you
Right.
think that's what went on?
I mean, I think they always talk to them privately. I did find it a little surprising, a lot surprising that she didn't take the time right then and there to tell them what a good job they did, that how, it was very short and she just turned and left. I had a judge do worse than that once, just like literally excused, get off the bench and like storm off. That was like a mini version of that. But I mean, she gave them like a little bit like thank you, but it's very typical to be like, you did your duty. You were so appreciative. Thank you so much. Like a very, a little bit of a nice reassurance right then and there. And
Ye-
she
And she didn't. Yeah.
no.
Show a little gratitude. Thank them for they sat there for, 10 weeks, a lot. And it was hot in that courtroom. The air conditioning barely worked. And there were a lot of delays, but I mean, the way she was complaining about the delays, it was like they were sitting around for half an hour. It's not that big a deal. They probably enjoyed their jury room more than they did the courtroom because the courtroom was super hot. And then for for closing arguments, they had to have Brian Albert, Colin Albert, Jen McCabe, and Carrie Roberts staring right at them. What did you make of that? Because we've texted a bunch, but we haven't really talked about things like that.
So, and I glanced over at your comments right when you said that you're talking about the exchange between Karen and John O'Keefe's brother. Or did you mention something else? Sorry.
Well, no, we didn't even get to that yet, but I'm just talking about during closing arguments, how they had,
Oh,
Brian Albert, Colin Albert,
right.
Jen McCabe, and Carrie Roberts precariously placed behind the O'Keefes, staring down the jury during closing arguments.
I mean, I definitely think that was the Commonwealths and the O'Keefes, or the Commonwealths using the O'Keefes to make a very public statement that we do not believe any of these people hurt our family member.
Right.
And it was I think that was very clearly the message they were sending to the jury, whether it was, whether it was perceived as sort of intimidating or anything like that, I can't necessarily speak to, but I definitely think that was their way of saying, we don't think they did anything wrong, so you shouldn't think they did anything wrong.
Exactly. That's one thing that I think it showed, and I don't know if the Commonwealth was involved in that, but definitely the O'Keefes were in charge of giving out the seats. So you
Yeah,
would
and
think,
I would expect that there was some discussion about what would make a very good showing with it. I can't imagine the Commonwealth didn't have some input or suggestion in that regard.
right. Right. And then, but also it's sort of like the way I took it. First of all, Brian Albert looked like he was about to bust out of his shirt. Like he was like, it was like you could see it getting tighter and you could see him like trying not to say stuff and you could see him mouthing the F word a couple of times or whatever. Somebody like slowed it down and zoomed in on him and he looked super uncomfortable. And he was in frame during Alan Jackson's entire closing. And then when Lally got up, they cut him out of frame, which I thought was so obvious. But it's also like, I've heard from a lot of locals who write me anonymous emails and anonymous comments and they're in the chat anonymously. And they're like, listen, you don't understand how afraid people who live in Canton are of Brian Albert. Like they're afraid to speak out. They're afraid. I don't know if anybody from Canton was on the jury, but it was also kind of like, I'm watching you. And
Right.
I just found it to be in such poor form. And why Colin Albert? Like he didn't even know Officer John O'Keefe, really. He was his neighbor. Maybe he cut across his lawn. Maybe he flipped him off a couple times, but it was so
Higgins there?
orchestrated. Higgins was not there. But it's
Okay.
like, okay, so you take 2 out of the 3 third-party culprits. Actually, the 2 third-party culprits that Karen named in her, it was an actual video, but they only let the jury hear the audio when she's like the charges are upgraded and she's arrested in June
Right.
on second-degree murder. And she says, we're all in on the same joke, right? Brian and Colin Albert beat the crap out of John or whatever. She says John was pulverized and my taillight was cracked. So the exact 2 third-party culprits that she named during that video statement, they have come in and sit across from the jury right during closings.
Yeah. Yeah, it was definitely that the a screaming sign that we don't think any of these people did anything wrong, any of these people had anything to do with our beloved's death, and neither should you.
And you're a practicing criminal defense attorney. So here's another question for you that I've been wondering about and I haven't had a chance to ask you. When they upgraded her charges to murder in June, and they go and they round her up at her house and they cuff her and they bring her in without a courtesy call to her attorney, Yannetti, who's been representing her by day one, how is that typically handled?
In my experience, when they amend the charges, they do it in court. My client knows they're coming in, and then typically, depending on the size of the courthouse, I've had a small courthouse be like, just run across to the jail and process yourself. Otherwise they get taken in, they get processed, they get taken back out. They do typically get processed again once it goes from, was the first a misdemeanor or were they both felonies?
I don't recall. I think it was a vehicular manslaughter charge
Which
with a
would be a
DUI.
felony,
It
right?
was a felony, yeah.
Yeah. So usually it's, to me, in my experience, I've seen it when it upgrades from misdemeanor to, a felony, but it might be on any significant new offense. I'd have to think about that, but it's very unusual to do what you just described. Like, don't let the lawyer know there hasn't been anything filed in court, and that they just show up out of the blue and arrest you on a new charge.
And they bring her
That's
in without calling her attorney, and they keep her overnight to arraign her again the next day. Like, wouldn't they call you and say, listen, we're going to upgrade the charges. Could you surrender your client? Could you bring
right.
your client in? I mean, isn't that what, I mean, did they rounded her up and cuffed her without calling her attorney? I just find that to be so intentional, so intimidating.
Right. And typically they usually just do it like the next court date, because or the state lets you know you got to come in person because we've upgraded and she's got to get processed. If they were doing Zoom court, like, so that maybe that's a difference, that they're not always standing in person in court. But yeah, that is, I would say, an unusual way of handling it.
Yeah, if you were the attorney, if I was the attorney, I'd be so angry. Like,
I'd
are
be
you kidding me?
pissed.
You didn't give me
Right.
the courtesy call to come and surrender her. I would have brought her down there. Like, you don't need to, and then tell her, oh, you can call your parents to bring you whatever you need for the night, because we're gonna arraign you tomorrow, and you're gonna be here again overnight.
Yeah, that is wild.
Not cool.
I didn't realize that's how they did it. I assumed
Yeah.
that was on some sort of like surrender, or, after court, or them letting her know, not that they came and arrested her and held her
Mm.
overnight again.
Yeah, classy, right? So Proctor's been, I don't know. He's on ice now, I guess we could say. He's not fired, because they have to jump through the hoops of the union. They have a very strong union. They have to do hearings and whatever else they have to do. But
Yeah, Bob and I covered this yesterday on Defense Diaries, and we were like, what is the most offensive about it is that they're trying to take the high road, like, we will not tolerate this and we will not stand for this, but then they're also trying to say this they're talking about is something they damn well knew long before it came out on the stand, long before the trial. So it's just everyone who's being intellectually honest knows damn well that they only waited so that the defense couldn't use it against Proctor and the Commonwealth during trial to impeach him. And
Mhm.
it's giglio material, or would have been giglio material, that they just decided, we're not going to give them this giglio material, so we're not going to put, we're not going to, and or Brady, that's just meaning it's Supreme Court law, long-standing case law that requires the state or government to give over any evidence that not only is helpful to the defendant, but could impeach, show bias, impeach the credibility of your witnesses, which this obviously would. Now, I don't know that I don't think it could technically be a Brady violation because it didn't happen, but it's clearly designed to avoid any Brady material, any giglio material. So, I'm like, all right, well, because they used words like what was revealed during trial. He also said what was revealed during trial and other places. There was something else he said in his words. And I was like, oh, okay, so are they going to say that there is something new? Like, well, we learned that the ring video disappeared when while it was in Proctor's possession. We learned that one of the officers saw her arriving home at, what was it, 12:21 or whatever it was, and then the ring that video just disappeared from the face of the earth.
Mhm.
Or we realize we're holding someone responsible for the inverted video,
Yeah.
you know, but then I guess that they are doubling down trying to make it appear as it's really just those text messages. And if it's really just the text messages, what the hell was revealed to you? What did you learn new during trial? Because they didn't need trial to know those were out there. Those were out there.
Oh,
You
yeah.
can
Right.
guarantee the police, that they had them come in and they had them, explain themselves. And, there was a ton of discussion about that before trial. So I just think it's disingenuous, and while they're telling the public trust us, they're
Right.
still being shady.
Well, let me just read. I'm going to read the entire statement because we didn't see the entire statement. I didn't play the whole thing. Okay. Following the so here is the statement from Colonel Maughan of the Massachusetts State Police. Following the mistrial in the Commonwealth versus Karen Reed, the Massachusetts State Police would like to offer our condolences again to the family of Boston police officer John O'Keefe. We cannot imagine the way in which this result has heightened the O'Keefe family's immeasurable grief, heartache, and sense of loss. John lived a life of honorable service, both to the city of Boston and the children entrusted to his care after the unexpected death of his sister and brother-in-law. We will remember him. Upon learning today's result, the department took immediate action to relieve Trooper Michael Proctor of duty and formally transfer him out of the Norfolk County District Attorney's Office, State Police Detectives Unit. This follows our previous decision to open an internal affairs investigation after information about serious misconduct emerged in testimony at the trial. This investigation is ongoing. Our focus remains on delivering the highest level of police services with professionalism and integrity.
I tried to make myself higher because I remember last time you told me that I was lower
I
than
just
you.
wonder you think I'm 7 feet tall. I know I could go lower. Hold on. All right, there we go. Oh, look, there we are on the same plane. So yeah, there's no apology to Karen Reed for the despicable behavior of one of its own. There's no apology to really the general public for this disgusting behavior. And again, it's only regarding these text messages, that were on his personal cell phone and nothing about the investigation and how shoddy that was and how improper it was for him to get involved in a case.
And someone reminded me, wasn't he one that admitted to driving after drinking his vehicle? I mean, that's
Um,
something new that was learned.
yeah. He's the one who went out with Kevin Albert, brother of Brian Albert, and they went to the Cape and got hammered. And then Kevin Albert said to him the next day, "Have you seen my gun? I lost my gun." And he left his badge in Proctor's car and said something like, "Yeah, come drop it off in my mailbox," or something. Like, things are still revealing themselves. Yes, they are still revealing themselves.
I just don't even understand how it doesn't scream into their own minds that most of the public is not accepting this because it's clear we waited till the end, which is just another game, just another reason not to trust us. If
Mhm.
you want honest oversight, why do you wait? Well, because it might have hurt the Commonwealth case. Okay, that's not fair. That's, dirty pool right there. You're literally saying we did something dishonest. Trust us.
Yeah. What do you think of a retrial in this case? I mean, they say they're going to do it. They kind of have to say they're going to do it now, but it's like if they say they're going to do it and then they don't do it, I mean,
Almost worse.
totally worse.
Like they could have said nothing, but I mean, let's just assume they are going to retry it because that's what they're saying that they're doing right now.
Mhm.
I mean, would you use Lally again?
I mean, he knows the case better than anyone, right? So
Second
I think they
chair him.
kind of have to.
Second chair him.
Yeah. But who
I
are they going to
mean,
bring in? Marcy? Marcy's never tried a case. I don't think Marcy's ever
I
tried a
don't know.
case in his career.
Do they not have a lot of assistants in that office?
I mean, they have that woman who was sitting with him, McLaughlin, who he barely let speak unless it was
Well, I can guarantee you if I was the defense, I would be filing a motion for a special prosecutor in light of what happened during that trial. And one of our viewers had pointed out in our chat yesterday, Lolly could be a witness with that inverted video, and it's very true.
uh-huh. That's
So I
true.
understand she denied a motion for a special prosecutor the first time around, but we have a whole different set of circumstances. She's seen a lot more come out. This implicates the district attorney's office and the investigators in the district attorney's office. and you could and that is a very good reason that Lally could be a witness. Why did you put on this inverted video?
Right. Right.
So
100%.
if they get a special prosecutor, that special prosecutor could say, I'm not prosecuting this.
Mm-hmm.
But,
I don't
I hold out. I think she should have granted a special prosecutor based on the first stuff. You covered all the pretrial stuff, so you know
Mhm.
well more than me, but that was one of the things that I looked at. It was like a couple of pretrial hearings shortly before, trial, and
Yep.
I think that they absolutely should have assigned a special prosecutor.
They made a motion to disqualify the district attorney, Michael Marcy, based on that hostage video that he did where he said, Colin Albert was not in the house and Michael Proctor never went there that day and this has to stop and the whole thing. I mean, that is like the number one thing that district attorneys should not do, and he did it. And he tainted the jury pool, in my opinion, to go all the way back. He released that video in August of 2023.
Oh,
And
he
the
absolutely
motion was amazing. I mean, if you have time, I'll send it to you to read. There were only portions of it that were made public, and I did go over it at length in the hearing, but she wasn't having any of it. There was a motion to recuse for that. She should recuse herself. And she did not obviously grant that either. And then there was a motion to dismiss the original indictment by the state grand jury because so many people lied, and Proctor didn't, Proctor didn't tell the state grand jury about the personal ties he had to all these people that he investigated. So
One of the other things I found interesting, because I'm a law nerd, so I do all my research trying to figure stuff out on the mistrial. Obviously, after a mistrial, double jeopardy does not attach. But I read a Massachusetts case that they can the judge can find there's insufficient evidence and then bar a retrial. Obviously, Bev is not doing that. I
no,
don't think in a million years, but it's on the table as a possibility. I don't think it's something the defense could really push for in light of the fact that there was an indictment. It's sort of like trying to do it before trial, but I think it's something they could ask for, but nothing they can do when it gets denied.
what do you think about a bench trial? I mean, maybe not with this judge, but if it was transferred to another judge. Mark Betterow was on here. He's a criminal defense attorney in New York, and he said he would go with a bench trial in this case.
I wouldn't, just because there's a lot of politics behind it, and if I see his point, right? I see his point because
Mhm.
a judge can be like, all right, there is clearly reasonable doubt just on the body, right? Just on the body.
Right.
But I always get worried, especially in the smaller the town. In New York, I probably would be like, yeah, bench trial. The judge is going to
Right.
be like, bullshit. But sorry, I
Mhm.
know you don't like language.
Sorry.
I won't drop
Just
the F-bomb
my
now.
people like listen with their kids in the room without headphones. It's fine.
Sorry, guys. Sorry, guys.
It's
I'll
fine,
try.
Allie.
Um, but in smaller towns, when you think about what it means for the judge to find not guilty and get like a lot of weight from other judges, from the people from the prosecutor's office, because even though we can see it sort of very black and white, how a judge could find that just on the injuries alone, and that
Right.
being just on the medical testimony of their expert. She said, even if you take the worst thing she said, which was it's both likely and unlikely. That was
Right.
that was the worst thing she said. I was like, Is she kidding me right now?"
I know.
Okay, that right there, I thought if Bev was being intellectually honest, they should have granted the directed verdict. And I don't know, I didn't see. Now in Illinois, and everywhere, I would imagine, you're supposed to renew your motion for directed finding at the close of the defense's evidence.
Mhm.
Okay, so now you've seen their case and our case. I want you
Right.
to rule as a matter of law, a reasonable jury cannot find guilt here beyond a reasonable doubt.
Right.
And if that maybe that happened off, outside of the presence of cameras, but I didn't hear
I
it.
was curious about that too, but I would think it would have to be on the record, right? It would
I've
have to
never
be on
heard
the
it not
record. It
on
would
the
be done
record.
in open court. I also was surprised about that because typically in New York, it's done the same way.
Or
You
it's
make
waived, right?
yeah. Um, she just sort of right after closings, I think she went right into jury instructions. I don't even remember if there was a break or if there was a sidebar or anything like that, but that would definitely have to be something that was done in open court.
In
So it would
my
be on the
experience, I've
record.
never heard it not be done in open court, but maybe maybe they did go in chambers and do you can do stuff in chambers that's still on the record. You have the court
Mhm.
reporter back there. I just would be surprised if this defense group would forget something like that. Like, it's a
Right.
pretty big step. Um, but at the end of the day, I can't imagine that Judge Bev would have granted it, although I just thought I honestly even thought there wasn't enough for the DUI. There
Well,
was
there
just
was no DUI charge, by
no, I mean,
itself. So, yeah, I agree.
for the
Oh,
DUI with whatever, just because I just didn't think they proved beyond a reasonable doubt that she was driving under the influence for the charge that required that because of the gap in time. In my understanding, Karen Reed never said the last time I drank was 12:45. So they're
mhm.
making up numbers. There's a huge range in the thing. The test has taken so many hours after the fact. But you know,
How about the testimony of people who saw her with 9 clear drinks? There was never any, evidence that that was all vodka.
right. I mean, I know they put in some receipts and this and that, but
2. There were 2 receipts
was that
of
all
a
it
receipt of
was
2
two?
Tito's and a beer.
Yeah, that it's
Somebody just pointed this out to me. I haven't seen this yet, but let's take a look at this from last night. Thank you, JH, for telling me about this. I don't know if you saw
Clearly,
this.
the only people who know exactly why the Karen Reed jury failed to reach a verdict are the 6 men and women in the room. But tonight, we have the next best thing to a fly on the wall, a trusted source who spoke to a juror directly and says they were never going to convict Karen Reed of second-degree murder. They just didn't believe that she intended to kill her police officer boyfriend of 2.5 years, or well, 2.5 years ago. They didn't believe it. They said no, all of them. They agreed. We're told that the jury dispensed with that murder charge right away, and then they split evenly, 6 against 6 on the lesser charges. You know, the lesser charges of manslaughter while driving under the influence and leaving the scene of a personal injury and death. And after being formally told to work through their impasse, we're told that the panel actually became, and I quote, very hostile. And eventually they could go no further. So what happens now? The prosecutors insist they're going to retry Karen Reed. They're going to do it again, in which case she will insist again that she was framed. A mistrial is not the same as vindication by any means, but the Commonwealth may very well want to take note of the one thing that this hopelessly deadlocked jury agreed upon. And that was that she wasn't a murderer, in their opinion, regardless of their charge and regardless of their case. In the meantime, there she is, hugging away, walking out the back door. She remains free till they meet again. Thank you for watching.
so I'm shocked that News Nation is reporting this, and I would be literally floored if this were true. So there was a tweet, and it was so everybody has to apologize. I apologize. I don't know like who players are. I don't know what
Right.
so I don't know all the people and the things. I've heard of the Sean El Jefe guy. So he
Mhm.
put out a tweet and it basically said that I've been told to hold back on this. The jurors are, they quickly discarded murder in the second and they were hung up on the lesser included. Now, when I read that in my mind, I processed it, even though it's not what he wrote, as they were that they discarded count 2 because it
Mhm.
makes no sense for those words to mean the murder charge. So in my mind, I processed it as count 2, and they were hung on the lessers because that's the only place the lessers go.
Right.
So then I had tweeted that, and then I kind of tweeted to people like, wait, I might have confused you even more. He is saying it was murder 1. That makes 0 sense. And then Bob and I did a live about it to explain it.
Okay.
So if this is accurate, what she's reporting, which I cannot imagine it is, this is what I have to say. When you say the words, we were undecided on blah and hung up on the lessers, the
Mhm.
lessers has nothing to do with count 1. As you know, count 1 was a standalone verdict
Yep.
sheet.
Right.
Standalone verdict sheet with only 2 options on it: guilty, not guilty. Now,
Right.
I can believe juries get confused, this and that, but those notes are what is the linchpin for me that this jury was a intelligent, thoughtful jury. You're
Yes.
telling me that somehow they decided quickly that she's not guilty on murder in the second, but didn't just sign that verdict sheet and move on to the next where they were hung? and report.
That's what, first of all, she said a source. So anytime anybody says a source, I'm a little
So the source
skeptical
was someone
anyway.
told me YLY, no, LYL, no, LYL or YLL, live something. It's like a YouTube people, either LYT.
LTL? Brian?
Yes,
LTL
maybe.
True Crime?
What is LTL? No, not what does
Let's Talk
LTL stand
Live.
for? Let's Talk
Let's-
Live. Yeah,
yeah.
something media,
That
LTL
Brian,
media.
yeah, that Brian was the source of that.
I
Oh.
watched his YouTube. He said the exact word, those exact same words. He did
And he
say,
spoke to like an actual juror on the case who told him that.
I'd have to listen to it again, but somebody in one of our viewers had like said to me, "This is where it came from. Watch it." So then I watched it, and I was like, "Oh!" And they said that those people are very close to the
They said,
to the
yeah,
defense.
people are saying LTL and Sean McDonough.
Right, but I think Sean got it from, I don't know, but
I don't
whatever
either.
the case may be. So I watched it. He did say, "I'm just throwing this out there. I'm getting this information quick. We're going to do it more thoroughly." So in my mind, again, I'm thinking, could he just be confused? And what they mean is on count 2 is what it was. But then she got it the exact same way. And if News Nation is doing that and not like just going based off of, I mean, that's very irresponsible. It's sort of like, I mean, I don't want to get into that whole picture thing, but the link you sent me today.
Yeah, I'm gonna pull up the Post article in a second. I want to, because I did want to talk to you about that. But here's the thing: when Mark Betterow and I were waiting for them to come in and declare the mistrial, after she did declare them, we were waiting to hear if they acquitted on any of the charges, right? So if this is in fact true, they would have acquitted on the second-degree murder, and then they would have been hung on the rest of the counts. Therefore, if they handed in that verdict slip with an acquittal on the first charge of second-degree murder, that would have been valid, and that would have been an acquittal. And then on the retrial, they would only be able to go after charges 2 with the lesser included and charge 3 of leaving the scene.
Right. And
But they
even
didn't
more
do
than
that.
that, and I just can't believe that they wouldn't have, as they're being pressed for a verdict. Well, let's at least tell her we reached a verdict on one.
Right.
And with the wording of that note, that was very thought out. They used like somebody was saying there's lawyers on there, could have been a lawyer. And at first I was like, you know what, that could be a lawyer. But then that very first note, and if you don't mind, I can bring it up because I typed them all out. If I still have it up, I might have closed it yesterday, but let me reopen. Read jury notes. Okay, here we go. And someone reminds me I've got to open wide to full screen.
You're getting so good at this, Allie.
I know.
You're gonna be able to host me whenever you want now.
All right.
Remember at the beginning, you're like, I don't want to host.
Right. Yeah. I'm like, I can't do that.
I know. Can you please host? I'm tired of talking. I say to you. And now you're ready. Now you're ready.
Oh, that's verdict sheets. Where am I?
Somebody said as a former cop, that's now a doctor. That's interesting.
Let me.
Thanks, Helen, for the Scottish llama. Needed Scotland's not proven compromise verdict. Thanks, Helen, for being a member for 5 months.
Okay, so that's the problem when I make it large. All right, so I have to share it, then make it large, because when I make it large, it won't let me share it.
I'll get Prestige Robot saying Melanie and Allie, beauty and brains and true grit the best. Yay, true grit. That's what we should call this. Right, true grit.
Now I'll try to make it bigger.
All right.
Is it in the middle?
Look at ye.
Okay.
So proud.
All right. Now I forget what the hell I was saying.
Well, just read it. Just read it and then explain it.
First note that these are the hung notes. There was an earlier note, so these are just the 3 hung. Dear Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. So with that, and we also had on our stream while we were doing this, Never a Truer Word, who does evaluates the words for what people mean, and also sort of like a body language person. It's a word.
Is that Sergio Denaro? I was just talking about him.
Is he's Scottish?
Wait, no, different guy. Go ahead.
So
Sorry.
he does the same thing, and he did that for us with Jennifer Bob and Jay, I can't remember if it was on the Shaming of Jay's YouTube or Defense Diaries YouTube, had him on, and he did during the break while the jurors had off, and he went through Jen McCabe's entire testimony, and brought out the 8 words that you know are a lie, like, absolutely not, you know?
Never. Yeah,
Right.
absolutely never or something.
Right. So at first I thought it was, and then he says to me, "Allison, would a lawyer write Dear Judge Canoni or Dear Honorable Judge Canoni?" I said, "Yeah, probably honorable." But then I looked at disputed evidence. That's a weird word for a lawyer to use, don't you think? Because what really was disputed evidence, you know?
Right. Unless
It
it was like he was pulling from the jury instructions, where it says you must consider all disputed evidence, and maybe it was just parroting back because they
Ah,
did receive a copy of the jury instructions to bring back with them. But what I thought was so confusing is that she said in her, because I went back after you and I were talking and I went back and listened to the instructions again. She said, I'm going to give you the jury instructions to bring back with you, but whatever I say to you, it takes precedence over the written instructions. And I'm like, what?
I
They
know
can't take notes while you're giving instructions. So how are they gonna remember that?
how confusing is that? So then do you want me to read all 3
Yeah, go
or
ahead, go ahead.
all right, so second hung note. Judge Canoni, despite our commitment, I had a typo in one of these, but despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. Now, I heard a bunch of people, like people just say this wildest, craziest things on Twitter, like
Mhm.
their state of mind, they were scared, their state of mind, they were, I'm like, I don't know. Did you read that into the use of the
No,
term?
because I know that in her instructions, again, she uses like when she says, you have heard text messages from John O'Keefe, and they are not to be used for the truth of the matter asserted, but they can be used to go to his state of mind and the nature of the relationship. So to me, I just feel like they're pulling words out of the jury instructions to kind of
For
throw
sure,
back.
for sure, and and
I mean,
and
that's what
just
I
saying
thought.
that we have differences in our opinions and state of mind, I in a million years wasn't reading anything into that to mean that they were afraid or they were,
Right.
anything like that, but the divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. And even if you're pulling from the jury instructions, which it's clear, yes, that's they're getting some of these buzzwords from that. It's still just a very clear, concise
Mhm.
note. I have never gotten any kind of notes like any of these. Like it's usually something like, we can't agree, Your Honor. Like
Right.
we're deadlocked, and I have had, I think it was only once that I had them send out, like, what their divide was. The judge did
Mhm.
not tell us, but she noted that she was aware what it was. Um, but, I mean, this is and the other thing that when we had, and it's so horrible of me that I can't remember his name, but never a truer word on, he was saying to him, this language shows unity amongst the jurors, even in their disagreement.
Yeah.
Like that they can't agree, but they were unanimous in this note. And it does seem like time was taken for the words. There's nothing superfluous. There's no, it's just very concise writing. And if it wasn't a lawyer, it was, someone, it just shows this group was intelligent enough even to think of, let's use the words of the jury instruction to convey what we want to convey. So because that they understood conceptually that locks her in. They
Right.
knew what to say so she couldn't send them back a third time, a
The
fourth time.
buzzwords, yeah, they
Right.
were using the buzzwords for sure, but I thought, by the time they sent out that second note, they may have thought, "All right, that's it, now we're gonna get to go,"
I
not
did too.
realizing that they had to get the dynamite charge or the Tui Rodriguez instruction or what we would call an Allen charge before, and got sent back again, and
And
then
if
they
there
did
was
take.
a jury there, a lawyer there, they would have known that, and if there wasn't, they wouldn't.
Well,
Is
a criminal defense attorney might, but, a real estate lawyer might not, or
That's true.
somebody who does a transactional, like, they might not know. I don't know.
Right.
I don't.
That's true.
Somebody said I think there might have been 2 lawyers,
But where are people getting this? Is this
an
things
engineer.
people are
Well,
making up?
No, because media was allowed in when they did jury selection. So there was media in there. So a lot of media knew, because they were questioned about
Right, yeah,
their
of course.
occupations and
Their
whatever,
background,
and
right.
we went over the jury questionnaire on my channel, and you probably did too. So they had to answer a lot of things, and maybe the media even got their names. Who knows? Hopefully they don't publish them and dox these people.
Oh god, I don't think they
Um,
ever would. She
but
said it was sealed.
I think somebody said there was an engineer on the jury, somebody who was in healthcare, but it seems like a very educated and intelligent group of folks who took
Yeah.
their job very seriously. And even after that second note, they did go back. I can't remember when that second note was sent.
It was on Sunday around Friday around, now my time, around like 10, so
Okay.
maybe 11. So, and that's sort of what I predicted. I'm like, they'll probably come back like early morning,
Mhm.
before lunch with a note, and then, you know, we were definitely saying on our channel we expected right after lunch them to come back with the third, because it was clear from that
Mhm.
second that they were not. There was no way.
It's coming
And
back to me now.
here's another thing that I thought was odd, because remember the first one came Friday, and it came early Friday, but then we were kind of surprised we didn't hear from them again, that they
Mhm.
actually did go back, like it actually worked. And I kept saying, you know what? The longer that they deliberate before they get the Tui Rodriguez charge, the worse it's going to be for them,
Mhm.
because they're putting in so much effort, and little do they know they're getting sent back again, and it's going to be like a harsher way to say it. But the judge could have, under their law, decided not to give them the TUI instruction and call a mistrial. And I was surprised that the defense didn't, based on this second note, didn't argue for that. Didn't say, Your Honor, we think one of two things should happen. We think, based on that note, that you should declare a mistrial now. They've made it very clear that this is, I mean, all the buzzwords we just talked about. In the alternative, we want you to give them the Tui Rodriguez charge now.
Right.
But they just asked for the Tui Rodriguez charge. And then
And
this
then
one,
that was the day that the judge sent a note at 3:30 asking if they wanted to leave, and they said no, we want to deliberate until 4:15. And then at 4:15 they came back and she just dismissed them,
does
right?
anyone know, does this what Judge Canoni always does? She has this time where I have never in my career had jury deliberations cut off at like the 5 o'clock hour. Even in federal court, I did have one that went several days. And, so we may have broke, early, like that first day or like the second day, but typically they go until like after dinner, or the jury asks to go home. Like I
Right.
don't see I've never seen a judge. How can they be expected to truly deliberate if you keep like after lunch they get another like hour and a half, 2 hours, and then they're gone, and then all over again? She
Yeah.
should have told them in jury while they were being selected during the trial, I'm going to be very diligent about letting you home by 4 o'clock,
Right.
whatever it is. But when we get to deliberations, which, that's a very short part of the, whatever, however she would word it, that's going to be longer days. So you guys make accommodations for those days.
I, I was surprised they weren't sequestered.
I know. I mean, it's hard to, I think it's just really
I worry
hard
for their
to,
safety. All right,
yeah.
let's go on to the third note. So let's read that one.
Judge Canoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspective on the evidence is starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges, plural, beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I
I
mean, that's
mean,
powerful.
well written, powerful. And I said this when this came out, and I said, I don't remember who I was talking to, the audience or Mark. I said, you can just see this division. I know that you're on Twitter. I'm not, but you can see this division. People who believe that Karen Reed is not guilty and that a car did not hit John O'Keefe are never going to change their minds, right? And people who believe that she is guilty because they don't like her facial expressions and because they think she confessed are never going to change their minds. So, I mean, you can see how in a jury room that could play itself out. And that's what these deeply held convictions may be that they're referring to.
Yeah, for sure. So it's just in light of those, I just find it so hard to believe that they would have just completely forgot to sign the verdict sheet or to tell the judge,
Right.
we've reached a decision on one count.
Right. Because they were allowed to, they could have done that. Thanks,
They
Mama
could have
Sita.
gone count-wise, they could have gone in any order they wanted. It was only count 2 where she gave them the supplemental instructions, which I don't know if, because I know you've had that, attorney, what's his last name? Bedro?
Mark Betterow. Mhm.
Federer on. So I don't know if you guys have discussed that Massachusetts rejected the acquittal first method, and they declared themselves a soft transition jurisdiction.
Oh,
And that
please explain that, smart girl.
okay, so that means and now we're only talking about count 2, which is its own piece of paper. I can pull it up if that makes would
Sure.
that be helpful?
Pull it
'Cause
up. Yeah.
I had that. I just
Speaking my
closed.
love language. Pull it up, girl. Allie's wicked smart, as you can see. She's a law nerd, like she said.
Right, yeah, like, it's actually
I'm a
interesting to
talker.
me
Mhm.
to have those discussions, and I think I just shut it down, and I don't know where I put it. Open
You
reset.
find it. Thank you, crypto tax lawyer. I mean, we are his or her favorite female attorney duo.
Aw,
Thank
thanks.
you. We appreciate you.
Hmm.
Adam Drives Helen, thank you. You're awesome. Number 1, you're awesome. Thank you. Number 2, would Alan Jackson go ham on this case again with even more fire? My guy got that dog in him. We ain't got no quit. Oh, yeah.
And then I heard that he's, not coming back, so I don't get it.
He's not coming back for that one hearing on July 22nd because he's gonna be on
Because
trial.
he's gonna be on trial.
Yeah.
I thought it
You
was
think he's gonna, like, give up?
not
No
after
way.
he said, "I ain't got no quit." It was so funny how Yanetti's like, "I'm not," he had to explain it, "I'm not from Texas," like, because look, I'm from the East Coast, you're from the East Coast. It's not like the nomenclature to sort of jest using "ain't," So he
Mhm.
was like, "I'm not from Texas like my esteemed co-counsel, but I'll, restate his sentiment. We ain't got no quit."
That's right, and it's so funny because I have a playlist because you and I both are music lovers, and, that's our thing, our music. Live music is our jam, right, Allie? That's our thing,
Yes.
and, so we have a playlist for this trial because I think in song lyrics, so every time I think of a song, I would put it on the playlist, and the viewers helped me, and, like, the first one was, like, Taylor Swift's Who's Afraid of Little Old Me because I was like, that is, like, Karen's song, and, we've got everything from, like, Pick Up the Pieces because of the taillight from the Average White Band, like, It Wasn't Me from Shaggy
Now
because I kept saying
that's my language right there, the funk.
yeah, we have a lot of that in here. We go all the way to, like, Friends in Low Places by Garth Brooks. We got some
Nice.
Twilight Zone by Golden Earring. I got Gives You Hell in here by the All American Rejects.
Nobody else would understand how in the hell this playlist got put together. Like,
Oh my God.
musically looking at it, they'd be like, "Wait,
Yep.
what?"
Red
But
Solo
that's so
Cup.
cool.
Right? You Ain't Seen Nothing Yet. Your Time Is Gonna Come, a Led Zeppelin tune in there. We've got it all. We've got Nowhere Man by the Beatles because we thought Lally was pretty much the Nowhere Man. Lunatic Fringe. But anyway, after that press conference on the steps, my final song of the playlist list is That's Right, You're Not from Texas by Why I Love It, which I love that song, and it's a
That's
banger.
awesome.
So you guys, I'm gonna put I'm gonna put the link to the playlist right now into the chat while Allie
I got it.
pulls
It's
up
up
or
there.
finds out. Oh, here it is. Here we go. Go
So
on.
so this is verdict sheet 1. You don't have to think about count 2. It's for offense count 1, murder in the second. 2 choices. Not guilty, guilty. That is it. That's all that's there. So now when you get to 2, and now bear in mind the real one has additional language after not guilty. It says not guilty of the offense charged or any additional or any lesser included offenses. So correct, the jury could not check off that first box if they were hung. So when we go back to what I was saying about an acquittal first jurisdiction or a soft transition jurisdiction. It is supposed to be that the jury is told that if you are hung on whether if you find the defendant, the Commonwealth has not proved its burden on the offense charged, that would be this offense charge count 2, manslaughter while operating a motor vehicle, or you are unable to reach a unanimous decision on that charge, you are to move on to the lesser included offenses. Now, after I read that law and the case that I read, and this was why it was different. The case that I read, the jury sent a note, and it was first degree was the offense charged and second degree was the lesser. And they said, "Are we considered hung if we are hung on murder in the first, on the main charge?" And the judge sent back a note saying, "Yes, that means you are hung." And then they appealed it, and the Supreme Court said, "No, we reject the acquittal first method." And they should have been told, "No, you're not hung unless you can until you consider the lesser includeds. Go back and consider the lesser includeds." So then, we can take this down now because it's not, but I'll say this. So then I went back to listen to the judge's supplemental instruction to hear what did she tell them about the order. She very clearly told them, first consider the offense charge this was all as to count 2, and everything I'm saying only deals with this one verdict sheet. And if you find the Commonwealth has not met its burden, move on to the lesser included. And if you find they did not meet their burden on that, continue in descending order. So I was like, that flies in the face of what I just read about acquittal first. So I did some more research. And what Massachusetts law says is pre-deliberation, that is the correct. You can instruct them to do it the way she did. First find not guilty, that they haven't meet their burden on the offense charge, then move down, then move down. But if the issue arises during deliberations, they're supposed to be told, if you can't meet if you can't agree on the offense charge, move on to the lessers. So that's when they would leave, they would move on even though they hadn't gotten past that. And then obviously they wouldn't check off guilty, but they'd have the option to check off either of these or to then report back, we are hung. And then for sure that they were hung on all 3 and not just hung up on one of the lesser includeds. So, and I don't think we need that up anymore.
But with regard to the first charge, if they all agreed not guilty on that first
Right,
charge,
they just that has nothing to do with count 2. They just should have marked not guilty.
right,
And so that's why what they're saying on all that's being reported, including News Nation, makes no legal sense. It makes
right.
no common sense. It's conceptually absurd. And because the jury does seem so like they took all this time and they really were thinking about it, I just can't imagine that is actually accurate. And if it is, what a travesty. What a
Yes,
travesty. But I can't it just doesn't it doesn't make any sense, especially when you're using the language that following up that they were hung up on the lessers. Well, that's a different count. That's a
right.
different part.
And she could have been acquitted of a charge 1, and then they wouldn't have to retry on that, and then that part of it at least would be over.
I just think
So,
they would have filled that out as not guilty. And then if they
right,
quickly discarded it, they would have quickly signed it not guilty, put it to the side, done
right.
with count 1, let's move on to count 2.
I
And then
mean,
they would have reported back to the judge, we are hung on some and we have reached a verdict on others.
you and I both were confused by those jury instructions, and if we're both attorneys that have been practicing for decades with law degrees and we're confused by them, imagine people who are not practicing law every day, how confused they are
Right.
or were by them. Satai, thank you for the 20. A sheet was modified to read innocent of second-degree murder and lesser charges. So if only lesser charges are considered, innocent is not marked, so no way to show that first charge is dismissed while hung.
So let's put this back up. So
Okay.
because this is what everyone's confused on. If we put the jury sheet back up.
Okay.
This is count 2, okay?
Mhm.
Count 2 is manslaughter. This one right here where I have it highlighted, not guilty, that is the only verdict sheet that was changed. And that was changed to add the language that Sati or Sati, I
Mhm.
don't know how to say it, is referring to. That she added the language of not guilty of the offense as charged or any lesser included offenses. Count one chart. This is the verdict sheet for count one. Karen Reed
Oh,
verdict
good. That's
sheet,
what I want to see. Count one. Right.
count
Okay.
one. It is just not guilty or guilty. That is it.
Right.
Same with count three.
Mhm.
Just guilty or not guilty. The only time you have the issue that we are all discussing is when there are lesser includeds, and it is only count two, manslaughter while operating a motor vehicle, that has the lesser includeds. So, and that's the precise reason why I sort of misinterpreted the tweet at first, because in my mind, I just equated it directly with count two because it's the only place that there are lesser includeds. It's the only place they can get
Right.
confused. There is not anything confusing about if we all agree murder in the second, it's its separate sheet. It stands alone.
Yep.
Initial it, sign it, done, move on to count two. And I think if that had happened, if uh the this had come back as not guilty and they reported hung here, maybe that's when the judge would have said, all right, well, have you moved on to the lesser includeds? But if they're hung on murder, meaning at least one person believes, and probably some based on the letter, but at least one person believes she intended to hit that person with a car, that it doesn't matter here because you know that they're they can't be hung on manslaughter if they um they can't come back not guilty on manslaughter if they're hung on murder. That's
Right.
impossible because
Right.
it, they would just
Because you have to go through that one before you can get to the next one.
right, and it's just clearly if you think they murdered her, you also think it was they would probably just check off guilty for all of them, and then it would merge at the time of sentencing. Like, even if they said guilty on all 3 slips of everything, when it went back for the purposes of the law, she's just guilty of murder because they all merged together. It's um but so that's why what everyone's thinking, you just have to remember when you're thinking about this later and we're off of here and someone's questioning you about this, just picture in your mind 3 verdict sheets, 2 of
Right.
which have only 2 choices, guilty, not guilty, and they have nothing to do with the lesser included. So if they really found count 1 murder was they very quickly decided anything on this, then they
Mhm.
would have filled out that verdict sheet. And if the judge is yelling at you that you need to, not yelling, you know what I'm saying, but saying you guys need to reach
Nudging.
your verdict, I
Right.
think you would be like, Your Honor, we worked really hard and we're able to to reach a verdict on count 1, but we're
Right.
hung on the others. It's just, to me, I cannot accept that is
That
accurate.
it
And I
didn't
don't think it's
happen.
intentionally false reporting. I think maybe there's a miscommunication in how it's being said versus how it's being interpreted. That
Correct.
somebody's, hearing they were hung up on the main charge and they had decided on the main charge and were hung up on the lessers. But again, even if that's what they were saying, because again, that's what I thought at first. I was like, well, if that's what they're saying, then still you'd have to assume that they found not guilty on murder. Why wouldn't they have filled out the murder?
Right, in which case there would be an acquittal on the murder, and then
Yes.
any retrial would be only on the other charges, right?
Correct. Yes, absolutely. Yeah.
Yeah, and that would be a huge win for Karen Reed and her team at that point. But
I
we
mean,
didn't
it's still
see
20
that.
years for involuntary manslaughter.
Yeah, but at
And that's
least there would be the
involuntary. Oh, no, involuntary
really?
is 3 or 5. The manslaughter, voluntary is 20 years.
But if he wasn't hit by a car, you can't convict on anything. So,
Right. And that's what,
there's
you know,
that.
there's the rub. And, look, I strongly disagree with the jury's the with the juror's opinion that there was enough evidence to show the car hit the body. But I have to say, and it's probably unpopular, especially on your channel, I
Say.
always ask when I'm doing my voir dire, I always, like, just insist to them, are you going to be able to stand up for your convictions? And if 11 people are saying guilty or not guilty, but you're not convinced, you personally, despite listening and are not convinced, do you have the gumption to stand behind and still say no? So
Right.
I have the utmost respect for the fact that they stood firm in their position,
Yes.
even though I'm surprised in their position, and that I don't understand it in any way, shape, or form. But that's what we want jurors to do. If you're
Mhm.
convinced, even if we all think it's wrongly convinced, if you're
Right.
convinced, have the gumption to stand up for your convictions and your opinion, and don't just give in to the majority. And I can't like that when it works for me and
Mhm.
not like it when it doesn't, but I still
Agreed.
think the jury system overall worked because the other people also kept, like you
They didn't
weren't
cave. The
right. It
person didn't
wasn't like
cave, or the people didn't
one
cave. They didn't get bullied into changing their mind, and that takes a lot of gumption, like you say. I mean, it takes a lot of guts to
right.
be able to stick to it and not feel bullied into changing your
Right. And it's
opinion.
like it still worked because even if you get those, if someone's like, well, we shouldn't have jurors where people can just make such ridiculous opinions, but that's why there's 12 of them. So that if someone's holding some sort of unthinkable to everyone else position, that's not going to rule the day. You've got 12 minds.
Yeah, and JH says perhaps they were initially unanimous on the not guilty in the second, and some wanted the report and testimony to confirm things, but because they were denied, they wouldn't commit. Thanks, JH, for your super
And I
chat.
mean, that is definitely a possibility. That's why they use the word quickly discarded.
Hmm.
It's not saying they came up with an agreement. So that very well could have been the case, that they were of a mindset that that was gonna be a not guilty, but they needed a little more, or they wanted a little more.
And this goes back to readbacks, which is something that you and I were discussing. And the fact that Massachusetts does not allow for readbacks of testimony, or they do at the judge's discretion. But in this case, the judge said both when she first swore the jury in and when she gave them their final instructions before they went back to deliberate, that you will not be provided with any transcripts.
And if it's really, and I don't know if you went back and checked because I just accepted what everyone else said, but if she really said because they don't have the actual capacity,
Oh.
meaning somebody doesn't have time to type up a transcript, or the way they transcribe, she can't read back or something,
Mhm.
like literally they are incapable. I think that that's like a serious due process issue because if she's got discretion she can't use,
Mhm.
what?
Well, I mean,
Because
she had
if you're
discretion to
saying she
recuse
said it,
herself too.
if you're saying she said it before the trial, if she told them that before, did she tell them that before?
That was when they were sworn in before the trial started, and she gave them some instructions saying, "You
Okay,
will not be
so
receiving transcripts, so make sure you take good notes."
So that's very clear that she did not use her discretion, that she couldn't use her discretion because she said it beforehand and
Mhm.
not based on what actually happened. And if cutbacks are causing that, it's ridiculous. But I did confirm in the law that they have the discretion to provide the transcripts if the jury asks for it. But they also have the discretion to deny it. But in this
Yeah.
case, based on what Melanie is describing and what is accurate, she did not have the ability to exercise that discretion because she was incapable of providing it to them. Or she exercised her discretion beforehand, which is not exercising discretion because how can you decide whether it's something that they should be entitled to before you hear the testimony?
If you're preemptively
Right, if you're
deciding,
deciding
right.
it
So,
before.
Shush and Giggle says she did the court was incapable of doing playbacks, at least heard it during jury deliberations. It's not even like giving them a transcript of the testimony. It's in New York, we still have old-fashioned court reporters with stenography machines, and they type it in and the paper comes up. And,
They
and
did it in
if
Trump.
yeah,
They'd read back. It was a read back by the
right.
at least I understood it to be a read back by the court reporter.
Or they'll say, read it. Can you read us back the testimony of an entire witness? And they'll come in and the court reporter will read it all back. It's
And
very commonly done.
I've had them transcribe it, and while the jury was deliberating, and The jurors actually sent a note like, "Do we have it yet?" And the judge is like, "We're working on it."
Oh, and they send the actual transcript back to the
And
jury
on that
in
occasion, they
Illinois?
did. They
Wow.
sent the actual transcript back, and it does say in Massachusetts that it can be a read back or sent back. They can do either one.
So interesting because, for a jury to rely on their notes, it's about, it's like relying on unreliable eyewitness testimony, which is the most unreliable form of testimony, right? Is eyewitness testimony.
For sure.
So now you're going to rely, if they were arguing about what notes said, what one person's notes said, and what another person's notes said, and then they said, well, we want to see the cert report to see when they started finding the taillight pieces, and there wasn't one, or the judge is like, no, you can't have it.
They would have probably asked for the read back if they weren't told ahead of time they couldn't.
Of
All right.
Tully's testimony. I
Right,
mean,
if I
wait,
can't
no,
get
O'Hara. It was Lieutenant O'Hara who was the head of the CERT team who testified about their grid search and going shoulder to shoulder, and all of a sudden the tail light pieces started revealing themselves. They found 3 and a sneaker.
in my opinion, one of the biggest things that hurt this jury, either way you wanna look at it, either side, was the hour limit on closings. But
Yes.
I
Let's thank Susan Vaughn for her very generous $50 super sticker. Thank you, Susan Vaughn. You're so, so,
Very
so generous.
generous,
We
very
appreciate you
generous.
so much. We'll buy
But
Allie and Bob dinner tonight.
but I have to admit, I did not the defense's closing was very eloquent. He did what he intended to do. That was his design, and he
Mhm.
delivered it impeccably. I just wouldn't have done it that way. I would have told the
Tell us.
jury, even if
Look
you
the other way. That was his theme, right? Look the other way.
no, that was Lally, right?
Wait,
Or
I
was
thought you
that
said the defense. I thought you said the defense is closing.
Yes, was that his closing, look the other way? I forgot
Yeah, that was Alan Jackson's closing.
okay.
Look the other way.
I would have focused on, even if you don't agree with the defense's theory, we don't have to prove anything to you.
Wait,
If
if you
you're
were
back there and
okay,
you're
got it, yeah.
tossing around other possibilities, you're saying, "What if it could have been this?" What every one of those possibilities that you toss around back there, anything that you guys toss around amongst yourselves, that's reasonable doubt. They just didn't focus on reasonable doubt at all. It was like only focusing on she's innocent, and everything, proves she's innocent. But they needed to be told that you don't need to agree with our theory. It doesn't matter if you think there was X, Y, and Z. What only matters is, did the state prove their theory? And if when you're back there, you guys are tossing around other ideas of what could have happened, well, maybe they did throw the canister at the mirror, or maybe he did throw the glass at the tail light, or, well, maybe she wasn't backing up, but maybe this happened. Any maybe that they are tossing around between themselves is reasonable doubt.
Yeah.
And I just felt like they needed to and I know that a lot of lawyers say, if the defense is going to pick something and they're going to stand behind it, that don't get wishy-washy and also give them, well, if you don't believe me, you can do this. But I think that's what needed to happen. Like, well, if you don't accept, our theory, just remember, we have no burden and we don't have to prove anything to you. We put forth a theory, but you guys can use your own common sense. Think about it. Think about all the possible different ways that you think it could happen. Don't listen to me. Don't listen to Lolly. Use your own independent judgment. But remember, everything that you come up with back there while you're doing that, if you do come up with other alternatives, each of those are reasonable doubt. Each
Yeah.
of those are reasonable doubt.
Right.
It's
It's so easy to press the Monday morning quarterback. But yeah, the 1 hour time limit really struck me too. I'm like, how can they tie this up in 1 hour? This is such a complex case. There was something like 29 days of testimony. I think the Commonwealth called like 65 witnesses, and the defense called like 6. To
I
have to
mean,
tie that up in 1 hour when a woman's on trial for a murder that could put her away for life
Lolly
seems
argued
like an
they weren't
arbitrary time limit.
very. Lolly argued with the second note. Your Honor, I'd say they haven't even done an hour for each day of trial, or whatever he
Mhm.
said. They
Mhm.
didn't even get a minute for each witness.
Right.
Not even 1 minute for each witness
To close on. Yeah.
to close on. And I don't know how I forget things. I forgot things, and we are, like, talking about them, which is the number one way you remember things, is
Yep.
by, like, continuing to talk about it. Here you've got a group of people who can't talk about it, so
Mhm.
they're not, they don't bring their notes home and, like, refresh.
Right.
They are not remembering even something that stood out to them. They are, you know, they have their notes, so they would likely have written that down. But, it was too short. But at the same time, it's very clear that wasn't what the defense wanted to say. Because how many seconds does it take to say every possibility you guys toss out there is reasonable doubt?
Right.
To tell them, well, if you don't believe the defense's theory, what about the insurmountable? I forget the word that the reconstruction used. I think it was like there is like an insurmountable amount of ways, infinite number of ways he could have hit his head.
Mhm.
That injury could have happened to his head, you know? And uh the key thing, like that was so huge that they put the reverse at a time that was not the time that she would have had the car.
Right.
Like, he established it on cross, but I don't think he hammered that home, and I had actually sent a text to Bob because I wanted to be able to show you the video that,
Oh, the key cycling thing? Because it
yeah,
was yeah, when I thought, and I mean, a lot of people pointed out that it could have been from when they were driving the car onto the tow truck.
right, that's what Bob says. Now, and that's I mean, but it's clearly not when it just it can't be when she was backing up. It just can't based on the numbers
Right.
alone. And, yeah, because I said to Bob, "Well, he wasn't going 25 miles an hour when he was backing up that car. He's, like, in the snow with the wheels turning." And I was like, "Oh, yeah, maybe, that could account for 25 miles an hour."
Mhm. But
Um,
when you see the video of them backing the car into the tow truck, because it's one of the few videos that we have that's not inverted or, it had a fake I mean, that had the real timestamp, but Proctor lied about the time of that in his reports, which is a whole other issue, but it looks like he could have been backing up 60 feet, the tow truck driver, whoever drove that car in reverse, and the tires could have been spinning.
right, and that
There was
could
a
have
lot of snow, there was, like, 20 inches of snow.
right, and that's what Bob was saying because I was like, "He didn't go 24 miles an hour in that," like, and he was like, "Yeah, but it the car could have registered like that. He would be pressing on it and the tires would be, rolling."
Did you do a
Um,
show on that? Because if you didn't, you should.
we talked about it because after the cross, I told Bob, I was like, "You know what? That's a huge deal." I'm like, I'm gonna dig in and I'm gonna
Mhm.
backtrack all the things and I'm gonna cross check. I'm gonna do my whole thing." And then I didn't, but there was this woman on Twitter who I'm horrible because I can't think of her name, and I
Somebody you're
know
fighting with on Twitter or
no,
somebody who's
somebody that
accurate.
Bob used their video. She did this video for the Murdoch thing of like, okay, here's the 5-inch man, like a whole reconstruction
Oh,
thing.
okay.
And she did a video on the keystrokes and which one would be which one, and very simply laid it out. And then people who keep saying, but he said that was the ignition. No, no, that's not what he said. A key works the same way as the press button. It's just
Mhm.
easier to conceptualize with the key.
Mhm.
When you press the button, it's still going on before it goes to engine. And the way we know that 100% for certain is because Jackson asked Trooper Paul on cross, but all of the keystrokes, is that what it's called? Keystrokes or
Key cycles, they
key
called it.
cycles, sorry guys, that the key cycles that you're talking about, we know the car was moving because you're describing where the car was driving during each of them. So whatever you want to call it, we know it signifies the car being actually on, the engine being on, because each time you're talking about it, the car was on,
Mhm.
So and I don't think they got, and that's I think a definite time issue, like with the hour,
Right.
um but
But it was based on mileage, like, there was no GPS, there was no time or date for any of those key
yeah,
cycles, it
but
was
how
just
do
based
we
on the
know?
mileage on the car.
That's what I was asking Bob too this morning because he said that. I'm like, that's the one thing I don't remember, and I have to go back and
Yeah,
re-listen. But how did they determine where to start with the miles? Because they were doing the same drive multiple times. Like,
right. Well,
you know,
He had a whole fakakta theory about, driving to Dighton and this, and here's what the mileage would have been. It was completely speculative and
Right, but if they
completely
went back even
confusing.
further, you know what I mean, to the
Yeah.
right, and then did all of the miles, because you just picked the end and did the miles and said it would
Right.
work, but you're talking about a small town where where that second part, that the piece that you're grabbing would have encompassed a lot of that same driving,
Yeah,
like
and there were
mileage.
missing key cycles. It was very odd. Nancy Rock says, "Thanks, Nancy. I was totally confused on those jury instructions. I thought that if you were hung in any, that they could not mark guilty or not guilty anywhere on the form."
Again, just remember, there's 3 forms. There's 3 forms,
Yeah,
2
and
of
they were all
which
separate.
all separate, 2 of which just say guilty or not guilty. It is only that second count where you can't check off any of the boxes if at all, if you're not in agreement.
Correct. Summer Gilmer, thanks for the super chat. The jury only asked for the cert report. There is no such report. That's right. Tully took all the information. They did not ask for a readback. They didn't ask for one because they were told initially they wouldn't get it. So
Exactly.
I have a big problem. I have a
That's
big
what we're
problem
saying,
with
that
that.
if they
Yeah.
were told they couldn't
Thank you,
get the
Summer.
report, and they didn't already think they were already told they couldn't get a readback, the alternative to that would have been, can we hear back Tully's testimony? But why would they ask for something the judge has told them they can't get?
Right. And they've seen her be a little snappish during the course of this trial. Like, if you don't speak up, we're going to turn off the air conditioning. So, I mean, not that they were afraid of her in any way, but if it's kind of like, you can ask, but you're not going to get it.
Right,
They
but
did
but
not.
they were told, "Take copious notes because you're not getting it." They're
Right.
not gonna ask for it. They were
And
told
I will
twice.
tell you that the day that I went to court, because I went to the court, I went to trial one day. I sat in on the day that Jessica Hyde testified and the beginning of Trooper Paul's testimony. And that was the day they had the first juror issue where one of the jurors was dismissed. So that took up a lot of time in the morning. And you were texting like, what's going on? There's no audio. There's no video. They cut off the video. They kind of punished the media because they caught that juror on TV for a split second, which nobody would have even known if they didn't point it out. But a lot of the jurors were not really taking notes that day. There were some that were, but out
Right.
of however many were left, I think maybe by that point there were 16 of them left. Like, not everyone was taking notes. So
And
I
if
don't
I'm the
really
defense,
know that
that's
it was
one thing I would
clear.
wanna know from
Yeah.
I wanna have my little person sitting in the gallery watching the jury just to put down when they're writing down,
Mhm.
notes. What are they finding, of interest? I'm surprised we haven't heard from that juror, though.
I know.
She wouldn't have gotten the spiel, and she'd feel a little, you'd think, a little upset, unless that's juror 3, because we've heard from juror number 3. Is that her? Oh, no,
No.
'cause she was alternate all the way to the end.
Yeah, in fact, I'm gonna have a little piece to play on that, juror number 3. But Gigi says, Allie, go look up Asget Industries on YouTube. She did the key cycle video, Defense Diaries. Yeah, thank you for that, Gigi. She
That might
did.
be who I'm talking about then.
Is she on Twitter also? I'm not sure. She does a lot of reconstruction videos. A lot of people are saying they should have, had them at trial. There are a lot of things that would not be admissible at trial, and those videos are probably one of them. So, go check her out. She has some pretty cool stuff on there. But I just have a little piece here from WBZ about the juror that did speak out. And let's take I don't know how much time you have, Allie. If you got to jump, feel free.
No,
But
I
I love
I moved my conference call, so I'm good.
to hang out with me.
Yeah.
When you get on like the routine of doing this like every morning with your people, and then everyone's like displaced when it when it stops. It's like, what do we do now? We're used to spending all these mornings together in the full day.
At 6, we are hearing from a juror in this case.
WBZ's Louisa Moeller spoke to a woman who was actually one of the alternate jurors.
I just spoke with a member of the jury in the Karen Reed trial. She would like to be referred to as juror number 3. Obviously, these folks have been through 9 weeks of hard work. She did not want to go on camera, but was willing to let me take some handwritten notes, and I'll consult them for accuracy. So juror number 3 was an alternate in this trial. That means that she was present throughout the entire trial, could listen to evidence and testimony, but was not present during deliberations. First, I asked her, how do you feel at this moment? She told me, quote, exhausted and disappointed. She told me she was, quote, not in the room where it happens. That's the deliberation. She said, quote, it was a lot to sit quietly in a room for almost a week. There were, of course, 5 days of deliberations. I asked her what she thought about this case and Karen Reed's guilt or innocence. She said, quote, "I approached this trial as if I was taking one of my graduate level classes. I would get an A+ in note taking." And then I'm paraphrasing here. She says, "I believe the Commonwealth did not do their job to convince me beyond a reasonable doubt that Karen Reed was guilty." Paraphrasing again, no one saw exactly what happened. She told me that watching both families throughout this process was painful and tragic. And then I asked her about Trooper Michael Proctor's testimony and his explosive and inappropriate texts about Karen Reed. She said his testimony would not have, even if it were not included in this case, she still believes that there would not have been enough evidence to convict Reed. As for the trial and the jurors, she says it was a lovely group of people. We celebrated birthdays. We even did puzzles together. Now, you've heard from my colleague, Christina Rex, and from legal experts that a jury is supposed to be representative of the public. And of course, if you talk to any member of the public, there's lots of differing opinions about this case. So there will certainly be more information from jury members and everyone else in the coming days. In Norfolk County, Louisa Moeller, WBZ News.
Really interesting there, Louisa.
So far, nothing else from any other jurors, but how frustrating would it be to sit through 30 days of testimony and not be able to deliberate at the end? People had reported that juror number 3 was pretty upset when she didn't get to deliberate, and I could see that. Lori Life 360 for the win. Thank you so much. Andy Bebb doesn't really care about her public persona. So happy Allie is here. Thanks, Lori.
So Bob did say, he came down and just told me it is Aztec Industries. She did tell him you could put it up as Get Industries.
Oh,
I
does
sent
he
it
want to
to
come
you.
on? Does he want to come on camera? Does he want to come on the air?
I sent it to you if it's something that you want to do or have time for.
I have
but she's
something
fine
else
with it.
because Sergio, this guy
Good.
Sergio Denaro, who's been doing, and like everyone has been sending me his videos, and I emailed him to say, can I play a little bit of this on the air? And he just emailed me back and said that I could. So I want to do that.
So
If you guys
before you
want to
do,
use,
let's talk a little bit about what you just did. 'Cause I
yes,
kinda
go
cut
for
you
it
off.
while I pull this up. Go for it.
So, I'm not surprised that the Proctor thing wasn't the linchpin, and I'm glad that it's not. I'm glad that she would have made the same decision without his, disgusting, offensive text, because it shows that they weren't just offended by that, and it wasn't just that. It was a lot more than just that, because there was a lot more than just that.
Mhm.
But that did show a level of bias and lays the framework for are these trustworthy? Well, is the investigation trustworthy? Are the Commonwealth witnesses and the police trustworthy? And when I say Commonwealth witnesses, I mean the police witnesses, like the government witnesses. And it also says that they were getting along before they started deliberating.
Yeah.
You
Doing
know,
puzzles, celebrating birthdays. I mean, so interesting. Okay, so this is Sergio Denaro. He has a YouTube channel called Truth Revealed. So many of you sent this to me, and he dropped the video this morning. I've watched all the videos, and he's talking about the 227 Google search, and he's I don't know if he's a linguist or if he's let me see what it says on his intro. The intro to his channel says, discover the science behind spotting lies through engaging tutorials on micro expressions, body language, speech patterns, and psychological indicators. Put your skills to the test. Okay, whether you're an investigator, law enforcement professional, or simply intrigued by the psychology of deceit, Truth Revealed is your trusted resource. Uncover the truth with us. And so Brian from LTL True Crime, funny that we're talking about him, asked him to take a look at Jen McCabe's testimony about the 227 search. And so I just want to play a little bit of this because it's so interesting. And he said that I could. So, I do not play other creators' work without asking them. So let's just take a look at this. And then I'm going to link his channel in the video description so that you guys can watch it on your own, because it is 39 minutes long. But let's just take a look and how he breaks it down. And we'll go on with this for a few minutes.
This is going to be very, very hard to explain away. And it's so relevant to the case that I really hope the jury was paying attention to this part. Let's look at this, and I'm really curious to see what you guys think about my breakdown on this testimony. All right, without further ado.
And this is the 2:27 a.m. Google search by Jen McCabe, Hostlong to Diane Cold, and her testimony about it. And so he breaks down her testimony and gives his opinion of what he thinks went on here.
Let's jump into this. I am going to be highlighting some stuff as we go along. I'm going to try doing this a little bit differently than I did before. What I want to mention before we get started, I want you to remember this. At 2:27 and at 6:24 a.m., we have a Google search for this right here. Now, when we look at this message, these messages have a bit of a different meaning to Jennifer McCabe. As we look at this message here, the 6:23 a.m., I'm sorry, I said message, I meant Google search. This Google search here, when she actually searched a different term, she searched how long TI die in CIKD. This is extremely important to us as interrogators. We are going to get some really good information from this. So I'll keep referencing back to this so you don't have to try and memorize what I have here. But this note we're going to keep jumping back to. Was there anything else on your mind that early morning hour time frame? So I've skipped some of the intro stuff that's not pertinent, but let's just jump right to where she does the Google search. She says, don't believe so. Here we have no use of the word I. When you have no use of I in a denial, that is no commitment. That lack of the word I here means that this is deceptive. This is a lie. Don't believe so. All right, Miss McCabe, if you wanted to know in general how long it takes for a human being to pass away because of exposure to extreme temperatures, what would you Google search? I'm going to play this for you in just a second here, but let's go through what she says first. And then
that was so interesting. Remember when Alan Jackson asked her that? Like, if you were going to Google this, what would you Google? And that was like not in her script. And he goes on to say that. I thought this was so interesting.
We'll actually watch her say it. She says, I'm not sure. All I recall is what the defendant asked me to Google in the morning. The relevant parts of her response here is she calls Karen Reed the defendant. And this is in reference to this time here, the Google search that happened at 2:27. And any time that she references that 2:27, she's going to qualify that by saying in the morning, because this is well rehearsed when she is thinking about that 2:27 Google search. She's going to constantly say in the morning. That's her way of trying to displace where you're looking. Remember, she Googled the exact same message here. Haas long to die in cold. She did that twice, once at this time and once in the morning. So every time that she is asked about this, or even if her brain just goes there, and she is automatically going to say in the morning, which is redirecting you to the second time. Okay, all I recall is what the defendant, and anytime that she is referencing Karen Reed, when she's doing that 2:27, that incriminating Google search, she calls Miss Reed the defendant, asked me to Google in the morning. In the video, before we look at it, we want to pay attention to where she's looking. So you got to baseline people. Most people will look up and to the left when they're trying to recall. When they're trying to fabricate a story, it takes various different parts of the brain to fabricate. It's very different. Being creative is completely different and uses a different side of your brain than it does to simply recall a memory. When you're fabricating, when you're creating something on the spot, you're going to start by looking up and to the right, and then you're going to start to search for information that's relevant to the story that you're making. So you might look down and you'll kind of look around, and that's you searching that brain of yours. We notice that she is looking up and to the left, recalling rehearsed testimony. Let's go back and look at that question again. And this, I think this was purposeful by Mr. Jackson. If it wasn't, I'm glad he did it. He says, if you wanted to know in general how long it takes for a human being to pass away because of exposure in extreme temperatures, what would you Google search? He is not asking her to pull back a memory. He is specifically asking her to fabricate here. Put yourself in this hypothetical situation where you were asked to Google search how long it takes somebody to die. What you would expect to see if somebody hadn't rehearsed anything would be for them to start that process of fabricating. They should start by looking up and to the right and then starting to look around a little bit, because they have to generate an answer. What would I say to that? That's a good question. How would I address that? Instead, she just bam, zones in on.
This is his opinion. So I am playing his opinion. Somebody said, is this based in fact? First of all, this is only a small snippet of the video, but This is his opinion based on his years as an interrogator for I'm not sure which federal agency.
Or he's probably in their division that does human factors type stuff.
Interrogation, I think, right?
Yeah, but
I
even
think
beyond that, the people that do
deceit.
like the interrogators have a general level, but then you get like that higher level of body language and all of that.
Yes. All right, let's see.
On a memory. So she could be recalling exactly what she texted, but in that moment, what she's doing is actually recalling both what she texted and then her rehearsed testimony for it. It's just a very strong indicator that her testimony is rehearsed and she is not actually answering the question the way that it was asked. So my note for that.
If you wanted to know in general how long it takes for a human being to pass away because of exposure to extreme temperatures, right? If you wanted to know the answer to that, what would you Google search? What phrase would you use?
I'm not sure. All I recall is what the defendant asked me to Google in the morning.
So my note for that is Jennifer McCabe has rehearsed statement for 2 different times of the day. One set of statements for when she's Googling at 2:27 and 6:24, and the other rehearsed statements for when she's Googling at 6:23. It seems to the common observer that the most intuitive way to lump these together would be the 6:23 and 6:24, because those are both Google searches that happened in the morning. But we want to keep in mind that we're looking inside the head of Jennifer McCabe, and she did a Google search at 2:27, and the Google search that matched that in the morning was at 6:24. Those are the 2 that are going to be linked in her mind. The 6:24 Google search and the 6:23 Google search are not linked in her mind, even though they happen one after another. So did you, in fact, use a phrase to Google search how long it takes for someone to die of extreme temperatures? That's just a yes or no question. Any witness on the stand should say, yes, I did. So she says, I did in the morning. Now we get that catchphrase, that in the morning, that qualifier. That to us, rehearsing that statement is an indicator of guilt. We know that if she has to keep tagging that in the morning, there's a reason that she's doing that. And that's to make you look somewhere else other than that 2:27. I did in the morning at the request of your client. We got Karen Reed is being referred to in legal terms again. So as a client. And again, that is anytime that we're dealing with the 2:27 or the 6:24, her name shows up in legal terms. Did you in fact use a phrase to Google search how long it takes for someone to die of extreme temperatures? I did in the morning. So she here is recalling both when she did that at night, which is what the question is, and then she's saying in the morning. So in her mind, she has the 2:27 Google search and the 6:24 Google search. After 2.5 years of this, you don't know the phrase that you used. And then she says, there's so many lies and misconceptions on social media. Whew, that is in left field. So that is not even a response to the question, but clearly that's a rehearsed statement. And we're going to keep seeing this over and over again. There's so many lies and misconceptions on social media. That is evasion. So she's evading the question and she's trying to displace blame. Are you telling me you don't remember what Google search you put in? Now that this is where she switches from calling Karen Reed by legal terms to using her name. That tells us that this is the part that she rehearsed for that 6:23 Google search. And the reason why it's linked to the 6:23 is because when she rehearsed, when she practiced the way that she wanted to present this in court, she linked the 6:23, the initial Google search, with Karen Reed asking her to do that. So she is bringing Karen Reed into this, saying that I did that Google search because of Karen Reed. And when she does that, she has to link Karen Reed to the first Google search because she's saying that she started this process because Karen Reed made her do that. And so she rehearsed this using the name Karen, not using client or a legal term. So now we're going to see why every single time she's referring to the 6:23 Google search, she uses her name, Karen. Now, what's her rehearsed statement? What did she practice? Let's find out. Karen was screaming, my hands were shaking, and she was saying, Google hypothermia. How long does it take to die in the cold? My note for the 6:23 Google search. And what phrase did you put into your phone? I'm just asking you to say it. And then she says, why don't you show me it? This is coaching. It's rehearsed, yes. but it's specifically coached. So you know that this wasn't Mr. Lawley who told her to say this. It wasn't anybody on the prosecution that told her to say this. It was someone in her group that was teaching her how to respond here, told her to respond like this. And I have a military background, and I went through a condensed version of SEER training, survival, evasion, resistance, and escape. And this comes straight from that. One of the principles is to admit nothing, deny everything, demand proof. So she here is not going to admit anything. She is going to simply say, why don't you show me? This is admit nothing and demand proof, which means she was probably coached by somebody with military training. And we already know that Brian Higgins was in the Army and Brian Albert was in the Marines. And now this is Sergio speculation.
So there you go. There, that's some of it. Go back and watch it. It is Truth Revealed on YouTube. And he's got a lot of information packed into these 40-minute episodes. And a lot of people say it's hard to follow. Yeah, because there's so much information in there. So much information in there, but I found it interesting.
And we just played back Jen's testimony and had the guy from Never a Truer Word on. And so he doesn't have a police background, but it's focused on the words that you are using and which ones are showing. And so there was a lot of stuff. And I so that was either on the Defense Diaries podcast or the Shaming of Jay, because Bob and I do coverage on both. I can
send me the link later and I'll attach it in the video description.
Okay. And I can,
unless you want to play some of it, sure.
I don't know that I'd be able to find it, but I'll put links into the shows, and I'll text them while we're doing this to see if they can send me the actual link to which one's show it is. But yeah, I mean, that's very interesting about the, like when she's looking up into the left, like as she's doing that, as he was doing it, I was kind of practicing like with myself, like if I'm thinking of something, like, all right, let me try to remember something, like where am I looking? And it was like, if I'm just trying to think of like something I don't know, like I'm going to come up with an idea. Yeah, I'm going to the opposite side than if I'm pulling up a memory.
Yeah, it's so interesting. And people are saying it's not accurate. I don't know. I guess if he worked for the Department of Homeland Security and the FBI, he probably has some credibility.
Yeah.
Like Darla says, as a 26 plus law enforcement officer, he's flat out wrong. No one can say someone is lying definitively as he is. We look for clusters of change in how they speak and behave. I don't think he's saying definitively. I mean, this is his opinion. This is based on his opinion.
Right. This is what to him, gives him signs that of deceit. I mean,
indicators. Yeah.
Indicators. I think
I find it fascinating. I find human behavior fascinating. Somebody wants to know, SC Shan wants to know if your Allie's court trainings are ever streamed anywhere.
Somebody else asked that, and thank God, no. I've just, I don't want to have to. We had like one of our high profile cases was one that was like all the cameras are like in your face all the time. And it drove me crazy because I was worried when I was leaving the house, what did I look like? Because they get you like, they use the worst picture they can find of you. And I get these dark bags under my eyes. And then I'm like, you know what? I don't want to worry about what I'm looking like. I wish that I didn't have to deal with like, I need to hold a press conference after every, court appearance, or they're following me. And then one day I decided I wasn't. So right after court, instead of stopping at the, all the microphones set up, I just went right into the elevator and left. And that night, the newspaper put in an angry Allison Motta stormed onto the elevator. And I was like,
man, really?
And I know it's not something that I should need to worry about or have to worry about. But, women, we've got, years of things being put into our minds about how we have to look, so it was definitely something that I was worried about and didn't want. It wasn't a worry that I needed to be on my mind in addition to like actual stuff that matters.
Yeah, well, you see what goes on out there on the cesspool of Twitter, how there are certain talking heads posting pictures of Karen's outfits, and her outfits are too short for court, and she's being shamed about her wardrobe and being shamed about other things, such as like this. And I'm very disappointed in the New York Post today because the New York Post is my go to newspaper, as you know. And the fact that they picked this up and ran with it is a little disturbing to me. But we're going to take a look at it because Allie and I have been talking about this. The title of the article, and go for the comments because some of the comments really take them down a notch. Karen Reed spotted canoodling with her lawyer as jury deliberated over whether she murdered cop boyfriend. This was 6 a.m. this morning because they're a little late on this uptake, but
Right.
now that's attorney-client privilege, it says. Karen Reed was spotted cuddling up to her attorney, Alan Jackson, outside a high-end Boston steakhouse last week as jurors deliberated over whether she murdered her Boston cop boyfriend in 2022. The iPhone Live photo appeared to capture Jackson, a star criminal defense attorney from Los Angeles, wrapping his client in an embrace with one arm around her midsection and another tight across her chest. On June 27th, outside Smith and Malinsky in downtown Beantown. I love Smith and Malinsky, so at least they have good taste in food. And here's the photo that they're talking about. And Allie, you said you looked into this a bit and found
Yeah,
that
and I sent you the actual photo, live photo that was supposed to be the original live photo as well.
Yep.
But when we first looked at it, it just screamed of it looked fake when we first saw it. Now, when it was on Twitter, somebody did screen grabbed the live portion of the video of the photo. So, on a Apple photo, if you press and hold, you get a couple seconds of playback. So it was like a screen grab of that. So it just everything looked off. The arms moving here and everything looked wrong. And it was like it very clearly screamed that it wasn't real. And then Bob's pointing out, like, I don't know if you see like this line here by the guy's elbow, the line between like the picture being taken, the person
Oh,
taking
here,
the
yeah.
picture.
Mhm.
Right. So we were like looking at all of that stuff and we're like, this seems like a deep fake, and then everybody's, going crazy about how we, are the Karen people who support Karen Reed. Regardless, they put everybody in the same box, but whatever. Anyone who challenges this is just being ridiculous. But why does his face look so blurry and everyone
Yep.
else's face not look blurry? Now, I will tell you, after I got sent the live picture,
Mhm.
it still has this blurry issue. It's not, I don't think it's quite as blurry as that. I don't know. I'd have to look at it, but it definitely looked less like a deep fake than what was on Twitter. So I was like, you know what? I'm just gonna say it doesn't look like it because I didn't know you can deep fake a live photo. Like
Oh, sure.
right. So in my mind, I was like, how would you deep fake that? So I was like, it doesn't look quite as a deep fake as before, but and then I kind of went back and forth, like thinking the person whose pictures being taken could have been Jackson. And then everyone pointed out the shoes. And I'm like, all right, good point. And uh but then I think that somebody else sent the picture out and they found, because News Nation did a whole thing on it, that it was
Oh, I
debunked.
couldn't find it on YouTube, but yeah, some people say this is him getting his picture taken. They're saying
I
his
think
wife was in town.
his
She was
wife
pictured
was in
having dinner
town.
with them.
The shoes are not his shoes, which was what everybody's issue was, that most people are saying that that's their photographer guy.
Mhm.
But the News Nation expert pointed out the hairline's not right. It would on Jackson in that picture, that it would be really easy to substitute the faces out of the people because their faces are all over. But the News Nation people were not using the original photo. They were using the same thing we're all looking at from Twitter, So
Right.
at the end of the day, I don't know if it's real or if it's not real. If it is real, I'll just say, in my opinion, it doesn't have anything to do with the case, but just as a woman, that if you inadvertently grope a woman like that you're not intimate with, I still think that's like an issue, because
Yeah.
clearly whoever's grabbing the person is trying to get them back from going into the photo. But there's also clearly a very clear brushing over the breast. And I don't think that's if that's an accident, that's an accident someone should be making with someone they're not intimate with, you know. But
Yeah. Yeah,
But
agreed.
I
But
think
I
it's
mean,
been debunked. I think it's been debunked is where
it just the hairline looks off to me. I'll show this photo that you sent me, the original live photo, but here's what they go on to say. I was eating dinner with my wife and I happened to look out and see them outside and it looked wrong and inappropriate. So I just grabbed the closest phone and took a picture, said the photographer who did not want to be named. All right. So already there's an anonymous source here.
and I
It
was
was just
thinking with that, how quickly was she able to do that? Because that was clearly quickly a grab back. Like how did she see it was inappropriate by the time she snapped the picture because it was just starting?
yes, exactly. It was just her attorney kinda, I don't know what you would call it. It looked inappropriate for an attorney-client type situation, which it absolutely would be if it was true. The Smith and Walensky where the snap was taken is not far from a North End restaurant where Reed and Jackson were earlier photographed dining with members of the legal team and wearing the same outfits seen in the embrace photo, a dark sleeveless top on Reed and a navy blue t-shirt and blue jeans on Jackson. So, they ran with this story, which is so clearly, I mean, if you look at it, it doesn't even look like him. Like it's a bad Photoshop
Right.
is
So
what it
yeah, they were
is.
pointing out the hairline doesn't match up with his hairline. The expert on News Nation was pointing out the size of his thigh. Um, I don't know that the arm thing is as much of an issue in the live photo because I also took and I could send it to you. I took a video of me pressing on the live photo, so it came out much better than when they were screen grabbing themselves with the live video.
Well, here's the one that you sent to me, which is purportedly that someone sent to you was the
Purportedly.
original live
That's
photo.
what
Yeah.
was said. I have no idea if it really is the original live photo, but when I opened it on my iPhone, it is a live photo. Oh, there, you were able to make it
Yeah.
go. And you can switch it to bounce and it'll just keep going and going. I don't know
Oh,
if you can do
no.
that on your
I don't know
computer, but on your phone. And and when you do it like that, that grope is to me doesn't is not accidental. And if you're a man, you should be a lot more conscious of yourself to accidentally grope a breast like that of someone you're not intimate with.
Somebody also said that the man who is actually in the photo with her that they deep faked Alan's face onto has tattoos, and so it's clearly
Yeah,
not him.
someone
I
else
mean,
said
just
that.
the whole thing is like,
Someone else said that too. I don't know if any of us know, but Aussie Insider has a great alternative pick.
oh, great. And
Yeah.
this
But
was
it's
posted
I
to
don't
ex
even know
Courtney Proctor, who is the sister of Michael Proctor. Well, that's kind of
Yeah, I
interesting.
noticed that. I was like, "What in the hell?" I don't know if she reposted it or what happened, but I did see that, and I said to Bob, "Is this person related is to the trooper Proctor?" Um, but, at the end of the day, it doesn't change anything about where we were in court, like, right now, and if a lawyer were to have an intimate relationship with their client, that is a serious ethical violation, and
Mhm.
on appeal, you might be able to argue ineffective assistance of counsel if you could actually point to errors. You'd have to first point to errors and then say those errors, they were not seeing the case clearly enough because of an intimate relationship. So at the end of the day, could it actually help Karen if it were true and she had been found guilty, which she hasn't. So
Yeah.
it doesn't matter.
I
I
mean,
just
if
don't
this is a deep fake that everybody ran with, it's like per se defamation. I don't know. I
I
don't know.
know. Well, if somebody knowingly put that up, it is absolutely defamation. Like I said that and someone was like, "You don't know the definition of defamation." I'm like, "Oh, well, yeah, I pretty much do." I mean, you just
Mm.
impugned the profession of Alan
Or
Jackson.
and the character by implying an affair. It used to be only
Right,
about
but even
women.
when you do the profession,
Mhm.
like, that makes it even more per se, defamation for a civil case. Can even if you're, um, but if people are putting it up not knowing, that's one thing, but the news, they have a
Right.
duty to at least make sure it's legitimate, and
You
when you already
think?
have so much sign, like, I don't know why his face would be so blurry and the rest wouldn't, but
It's like, this is what they're doing. This is AI. Welcome to AI. It's gross, and this is what this is all they're running with. Thank you, Maureen Gunn, for your $20 super sticker.
I will
Appreciate you
say
so
this,
much.
my cousin is in, like, computers, and he's does, all this type of stuff with AI, and he was telling us last year that what we're gonna see come out during uh, uh, this year's presidential election, like that it's going to be shocking to us, the number of like deep fakes and like he's like it's going to be insane. Like it's like they're doing so much with deep fakes and all of this that there's sometimes not any way to tell. And I think the was that the Post or who was that you
That
put
was
up?
the New York Post
So
that
the
ran with it this
Post,
morning.
like they relied on the fact that the metadata said they were in Boston, but you can literally edit the metadata on a picture now.
And we
Like,
learned that during this trial.
right,
during
and
the
I
Karen
didn't
Reed
know
trial.
that, but when I got this, I clicked the little eye, and I was like, "Oh, it does let me edit the time. It lets me edit the place, like if I had wanted to." And there was sound associated with the live video. That was the other thing that News Nation said, that sound, just the sound portion of the clip, had clear signs of altering.
Mhm.
So, I mean, with hearing that, and I'm pretty sure I'll have to go back and look, but the girl who sent that photo, I thought she put up something saying she tried to get other people to look at it because she didn't want people thinking she was a liar. I'm like,
Mhm.
well, it's not your fault if someone tells you it's real, and then you say, okay, I believe it, but that they couldn't say that it was real either. There were issues, but it was just I just remember the Post wasn't clear. Like, yep, I've confirmed it's legitimate. And then
Right.
the Post just goes off with it.
Yeah. I don't know. It's gross. And like, that's what we're, resorting to now because we're going to keep this on the front page until the retrial. And how long is the retrial going to take? And somebody asked about July 22nd. It's just going to be a status conference to see when maybe they'll pick a date for the retrial. Merfetz, thank you. Says, so glad someone else found the key cycles wrong. My rough count is a minimum of 5 after she dropped them off.
I
Defense
sent
needs
you
an
that little
expert.
video, I think, if you want to put it up. It's very short.
Oh yeah, sure. How did you send it? Just joined, but it wasn't.
I
If it
texted to
wasn't
you.
mentioned, said Bride of Frankenchuck better won his case in New York. No, I did not see that. Thank you. I've been on here, so I have nothing to. Thank you, Maureen, and thank you to Merfetz. Did you text it? Let's see.
I did.
Did she say that we could
She did. Yeah.
play it? Okay.
Bob talked to her. Yeah.
All right. So all right. So this is Asget Industries.
Yep.
I will credit her. So let me just move it over here. And of course, I will give her full credit in the description of this video. So please go subscribe, like her stuff. Many, many of you have pointed her stuff out to me as well and shared it with me. So here we go. It's 3 minutes long.
This is a 3D illustration on the subject of key cycles, which is a very important piece of evidence that is widely overlooked. The data in this key cycle is referring to everything that creates this scene by Trooper Paul. And if he's wrong about the key cycle, it destroys his complete case. So let's start with the basics. This is a simple ignition switch. When you turn the key fully, you'll hear the engine start.
Same thing with the press key.
You'll release the key and it falls back to its on position. Then, of course, if you turn it back fully, it turns the car off. Now you can stick the key in and turn it simply to the on position. This is a key cycle. Then when you start the vehicle, this is an ignition cycle. All these cycles are recorded in logs. Every single time since the birth of the vehicle, every key cycle is recorded and logged. Even when you fully start the vehicle, creating an ignition cycle, there will always be a key cycle logged. So when Alan Jackson asked Trooper Paul if every ignition cycle has a key cycle, the answer should have been yes, but that would have hurt his case. So he was either deliberate in his deception, or at the very least, he lacks the expertise in the field to know better. Let's view that interaction.
Every ignition cycle includes a key cycle, correct?
In a sense.
By definition, it has to, right?
It doesn't have to.
To clarify, regardless of the expert's opinion, every turn of the key is a key cycle that is recorded. So let's look at what key cycle numbers they're fighting so hard over. It's right here. Key cycle number 1162, out of Trooper Paul's report, which goes with the trigger report that has all the throttle, braking, steering, and speed information that was created in this scene. The problem is, when the key was put in creating key cycle 1162, it wasn't Karen putting in the key. Let me show you how we know this. Trooper Paul started the car, creating key cycle 1164 during his testing. Moving backwards in time, we know the next key cycle was when the SUV was drove off the tow truck and pulled into the police department's garage. This would be cycle 1163. When the police department took possession of Karen's car at her parents' home, they started the vehicle and drove it on the tow truck, creating cycle 1162. Continuing, earlier in the day, Karen and her dad started the vehicle and drove it from John's home to his home, creating cycle 1161. And going back one more time, when Karen left John's home at 5:07 to drive to Jennifer McCabe's home, this would have been key cycle 1160. Now, these are known key cycles. There can be many more that are unaccounted for, but the point of all of this is that 1162 wasn't Karen. It simply doesn't match, no matter how they try to justify or equate things to be different than they really are. It's just nonsense. Key cycles are recorded for a reason, or the system in Alexis wouldn't work correctly when collecting data. It's that simple. Thank you for watching.
Interesting.
I mean, and again, she doesn't need to put everyone. That's what she's saying. There could have been more, but these are the known ones. And it nonetheless, you can't get to what happened in front of Fairview any earlier than 11:59. You just can't.
Mm-hmm.
Right. The
Right.
latest cycle possible. Exactly.
Yeah, very interesting. So follow her on YouTube. Asget Industries is the name of the channel. But if you go by the it's at AsgetFX.
And I just found they sent me the link. I sent it to you for that episode where Never a Truer Word did Jen McCabe's. We did Jen McCabe's testimony. I stuck
Oh,
it.
cool. All right. I'll stick that in the chat.
I
So
stuck it in the
that
chat too.
you want me to stick it in the chat? Stick
I
the
stuck
link
it
in
in
the
the chat too, I
Oh, you
think.
did. You put it in. All right. And then I'll
Mhm.
add it to the
It's on.
description so you guys can watch it later.
Let me double check that I didn't just put the Aztec again. No, I think I did the right one. Okay.
Let me see.
Wait, maybe I didn't. I'll just put it again just in case I just did it wrong here. Oh yeah, it was the same one. All right, I did it twice.
You got it?
Yeah. But I mean, and an hour is not enough time to explain all of this.
No.
It's just not. And what about the fact that the ring, like I just, if I'm dying to know when they learned about the inverted video, for
Mhm.
like, because there was an objection during the testimony, but up front when the Commonwealth had Buchanan on, and then that's the time, if you remember, Karen Reed seen turning her face towards the camera and saying to someone behind her, "It's backwards." So I
Mhm.
feel like that the Commonwealth already knew. Why in the, if that is true, just say that, why in the hell would the judge allow him to put on that testimony? Like, it's just mind-boggling to me.
Mhm.
And then the ring with the guy took the notes and said, "I saw this, looks like when she came home. He's the only one with the like, he didn't really, and the fact that the Commonwealth was still arguing in closing, that somehow she was responsible for that missing ring video. Still asking for a consciousness of guilt art instruction.
Right.
I want a consciousness of guilt instruction because she had she's responsible for a video being deleted that your own experts got on the stand and said the computer didn't do it. She didn't have access to it. Her phone didn't do it. And then he still argued she did it.
Oh, it was the shoes for me.
Oh, the shoes.
She didn't
I'm
take
like,
off her shoes because she knew he was dead and he wasn't coming home, and she knew he had a strict rule about it because she didn't take off her shoes. That said, she's guilty. I was
I mean,
I had secondhand embarrassment during that part of the closing.
it was the only
Really?
time I actually spoke up, like, over the closing, was as he was going towards it. I was like, "Not the shoes."
Yeah, he actually used it. Anne says, "How lucky am I that Michael Proctor's now working across from my house in South Boston?" I don't think he's doing any work in Anne, so I don't think you have to be worried. But it's going to be a big thanks, Anne, for your super chat. It's going to be a big problem in the Walsh case because he's handling the Brian Walsh, or he's the lead investigator. Or maybe now he's just a case manager or the call center guy for the Brian Walsh case. But Google searches are a huge part of that case. And Sunshine Cheryl says Brian Walsh Google search is reliable, but Commonwealth says Jen McCabe's are not. Really?
I know, that's what I wonder when they pull this shit and they say that deleted calls aren't deleted calls, then how they expect to be able to use that against somebody later.
You can't use it as a shield and a sword, right?
Right. And I mean, even if we believe, okay, wait, Google searching, it's getting confusing and there's all these different things. How in the hell a call is either deleted or not deleted? A call is not getting put into some temporary folder if you didn't actually make it.
There's no self-deletion mode, apparently,
I mean,
according to
even Whiffen said, I could not recreate this automatic deletion. I could not recreate it.
Whiffen did an infomercial for his own software. That was Whiffen's testimony. He created his own software. He got on the stand and did an infomercial for however long he was on the stand about his own Artec or whatever his software was that he invented, or his app or whatever that has 600 worldwide users that he gives away for free. I mean, he got on there and he blasted Celebrite, who I think is still his employer,
I think
to
so
say that
too.
we knew, and when he said we meant Celebrite, we knew that our timestamps were wildly inaccurate. So we stopped putting them up. Like, I kept watching the stock price of Celebrite to see if it would tank.
Did it move? Did you really watch
It did move. I'm going to look it up now. Teresa says, I think maybe AJ should bring in expert after expert to disprove that John was hit by a car and the car did not hit a person. That's what they did, though. That's what they did. Thanks, Teresa.
I think the only thing they needed to do different was put on an expert about the ring cycles, the key cycles, like that.
Yep.
That data, their huge thing, and the Apple Health stuff. If there's a retrial, I expect that they're gonna, spruce up their experts for that kind of thing, and they've got to get someone who knows the Lexis data. One of the government experts did know about it, but the defense wasn't allowed to employ him to do anything more than he already did. I wonder if they could on retrial, they could say, we'd like you to also assess this, or at least get somebody else, to do it.
Thank you, the Pilgrim Shadow. Well, Celebrite stock price is at $12.20 a share today, which is around where it was the day that Ian Whiffen testified. It did go down a little bit. It was under $12 at one point. And it's on the NASDAQ at CLBT. If anybody wants to keep watching the stock price to Celebrate, $12.20 a share today.
And by the way, I didn't even use the correct iOS. So,
He didn't.
which also one of your people just commented on. Beth D. Whiffen didn't test on the correct iOS version, and it's true. And he also told us that in like a point something, they made a change. So that the iOS from 15 to 15.25, they make actual substantive changes because they did one of theirs on one of those point somethings of an iOS update.
Right, and didn't the defense expert use all of the different iOS versions? He tested them all. So there's that. At 80 says, what's the hearing about on the 23rd? We're going to talk 22nd. It's July 22nd, 2 p.m. And they're going to discuss perhaps a new trial date.
I think that's what the judge was expecting when the Commonwealth would have announced whether they intended to try her again. So,
But
yeah,
they've publicly announced it already, unless they're going to change their mind. Chibi says, maybe don't have Madam Court Reporter do exhibits. She was doing it all. She was speaking into that little muffler, athletic supporter looking thing, and ridiculous.
I wonder if all of the criminal defense attorneys that have to have juries are now asking to be moved to that smaller courtroom. And that's outrageous that they just...
How unconstitutional that you would have to look at the back of a witness's head to determine credibility. And that's the way we've done it for 100 years.
I mean, it's literally the basis of the confrontation clause.
Right. Freedom Ring says, thanks for the 5. John was intoxicated and could have walked into the path of the car. Karen didn't see. John's fault. Should have been argued in the alternative. What do you think about that, Ellie?
I just think that any alternatives, that kind of being tossed out there, but I just don't think he could have walked into the path of the car because I don't think he got hit by the car. That's kind of the problem. But you've got to give. I think an alternative could have been that he threw the glass at the, but even that doesn't. I don't think that these experts were saying that's what we've decided happened. They were saying the only possible way that the contact between John O'Keefe or the cup and the taillight could have happened that resulted in that damage to the taillight would have been if he threw it. But then he also said it would have shattered and, and all of
They
that.
built a
But
cannon. They built a cannon to shoot that glass out of the cannon
I
at
was
the
telling
car.
Bob, a good alternative would have been he's throwing the glass and he loses his footing and he falls back. But even then, he's got to hit his head in something other than the curb if he's up as back as he was.
He could have slid back to the fire hydrant and smacked his head on the back of that top of that fire hydrant. But
Right, or
then
the electricity box or
how do you explain the arm injuries? Did he get
if
attacked by
he
a wild
falls all the way
coyote?
back there, there's some trees or bushes or something. That's the point. The point is that that's why I just think my closing would have focused on if you're up there saying, what if, but maybe, could it have been? Each of those things are reasonable doubt.
Preach, sis. Preach. Somebody says, Jadzia, he would have had frostbite if he was in the snow for that long.
That's what Bob said too. When I say Bob, everybody, that's my husband and co-host of the Defense Diaries podcast, YouTube, and actual podcast.
Then there's a QR code right behind you so people can.
Oh, yeah. There you go.
I will actually put the link to your channel because this was a surprise that you came on in the video description. Bob and Ali Motta, co-hosts of the Defense Diaries True Crime Podcast, and they even went to CrimeCon, you guys.
Yes.
They went there.
We have True Crime Podcast Festival coming up in Denver.
Oh, really? When's that?
I think like the 13th-ish, around July 13th, somewhere around there, because I know it was supposed to be the first time that I was babysitting my new grandchild. And then I found out I'm not here. So my oldest daughter is doing it instead. And I know the babysitting was supposed to be July 13th. So it's around then.
So it's like 10 days from now. You're going to Denver and you don't even know it.
Right.
Sure. Congratulations, Grandma.
Thank you.
Storm Dancer, thank you. The 5 a.m. video clearly shows her taillight was not shattered when she left to go look for John O'Keefe, Officer John O'Keefe.
I agree. And that's why I'm saying I think that was just them saying it was a possibility, not that that's what actually happened.
All right. Virginia, FBI are working all over the state, multi-jurisdictions. Yep. Mamacita, thank you. About who spread the bogus jury split claims. Don't like to say that name on my channel. Maria, maybe Officer John O'Keefe was investigating something that led to Colin. Maybe. That's one of the theories that's floating around. An Eclectic Mime, thanks for gifting 5 memberships. Brown-eyed girl, thank you for your Canadian super chat. Apparently, Officer John O'Keefe reported to Boston police that Colin was involved in some kind of exchange of, illicit substances, and that's why the Alberts were after him. I don't know. That's, again, rumor, speculation. We don't know. I have no concrete proof of that, and the opinions of my viewers are not my opinions, nor are they Allie's opinions, unless we specifically say, this is my opinion. Jen, thanks for the 5. Lest we forget, Kevin Albert and Proctor were drunk, losing weapons and gear in a patrol car while on duty. It's incredible.
Yes. Jen Del Rio, yes.
Strains credulity. The Pilgrim Shadow, Grateful Dead's Bertha was inspired by a broken fan.
Oh, so speaking of which, Bob is really gung-ho. I'm sorry, I spoke over you.
No, please do.
About coming to Vegas for that.
Yeah, don't say when.
In August. Oh. Sometime.
Listen, you want people to know where we are? I saw Peter Tragos the other day, lawyer, who I love. I think he's wonderful. I think he has a great channel. He was in, I don't know where he is, Disney, Universal, somewhere, in a hotel, and literally said the name of the hotel that he was in on his show. He's like, hey, I'm at this hotel. If anybody wants to come hang out with me. I was like, dude.
Come hang out with him?
Dude, like, you have just started covering Karen Reed. And if you know, because you're on Twitter, like, they will come for you. They will come for you, Peter. Do not tell anyone where you are ever. But yeah, let's talk about that. Let's meet at the Sphere, because that's going to be really fun. A big piece of this case puzzle is how and why did the feds get involved? Tip, flip, or wiretap, or all? I think they were investigating something else, and this was collaterally something that they found out about. You have any thoughts or opinions on that?
I don't, because I didn't follow this pretrial. I only remember Lolly at least arguing in a pretrial hearing that one of those last couple, that it was the defense who gave them the information, and then they started to investigate. But I have heard that they were already investigating Canton, including,
Mhm.
and a friend of mine in Boston told me this.
Sandra Birchmore?
That's it. Yeah. And I
Yeah,
was
she
like,
was a young girl who was, like, groomed by police officers. They passed her around like a and she was, like, 13 when she got involved in this police yeah, it's gross. I'm gonna start digging into that next, but
yeah,
then
that's she
she
was like,
wound up
you're gonna go crazy. That they said it
yeah,
was suicide, and now they've changed it to homicide.
she was pregnant with a police officer's baby.
That's what she told me. I was like,
Mhm,
"Oh my gosh, no wonder that maybe that's
mhm.
the feds were investigating."
But, yeah, like, maybe I think maybe they never investigated or they never tested the fetal tissue, maybe, and, maybe Lank or Proctor was involved in that investigation too. Like, it happened in Canton, so it was investigated by Canton PD, even though the girl, I think she was from Stoughton, or, Stoughton cops were involved with her. Horrific, horrific. But again, same cast of characters in a lot of ways, and we don't know. Maybe they were investigating the DA's office as a whole. We don't know. They've never said who the target of their investigation was. Thanks, JH. What does the court do if the jury ends up reporting now that they were confused by the verdict sheet and meant to acquit for second degree? She said capacity.
I don't think there's anything they can do.
Nothing. It's a mistrial. Still a
And
mistrial.
they don't need a mistrial because it's already a mistrial, right?
Exactly. JH, thanks for answering my questions. 1 hour was too little and should have reiterated most of the key witnesses previously lied under oath, so can't rely on the evidence. Yeah.
Very true.
Pilgrim Shadow, thanks for the 5. Grateful it's loser for Proctor. That's a good one. Touch of Gray with refrain, we will survive. We will get by for all of us. We will. And this is the case that will never end, has never ended, and is still going to be covered by all of us. Karina, have you watched Microdot's new video? You should. No, but I will.
I've seen a couple of their videos. I'll have to figure out what they're talking about, but they're usually good.
They were actually hired by the defense team in this case.
Oh,
And
really?
the only exhibit of theirs that they crafted, let's say, was the 3D rendering, and not 3D rendering, it was the outside of the house that was used in some of the defense during some of the witnesses, but I think they had created other things that were not allowed in. So
Mm.
shout out to Microdots. Thanks, Sharon, for the 10. Thanks for doing this. I've been lost the last couple of days. I was so sure she'd be found not guilty. I just assumed everybody was watching the same trial. Do you think she should have testified after all? Nope. Nope.
Yeah.
Members, put that nope emoji in the chat. We have a whole set of emojis for members just for this case. And the one for that is nope. What do you think, Allie?
I mean, I just think no, because so many people are turned off by her like demeanor. And I
Mhm.
actually had a case where, and it was there was an affirmative defense. So our client pretty much had to testify, although we did really think after the close of their evidence that we might have had it in the bag. And he did testify. And one of the jurors told me they hated him and like he was rude and they didn't like the way he came off. Like it wasn't really what he said, but they thought
Right.
he was snarky or they thought he was, so it's so hard because I'll tell you, Bob and I are a lot, we don't believe that you can just rely on reasonable doubt. We believe you do have to prove your client's innocence in this day and age, even though they're supposed to be presumed innocent.
Right.
So he didn't have a lot to hide from. So it wasn't even so much as that, but just her. i- If you throw them off on their personality, I mean, it's so hard to say. And she could be, you know, kicking herself for not doing it, thinking that had they heard from me, I mean, look, Proctor overcame, he had to go through a lot to testify, and he was able to, it didn't throw off all the jurors, so maybe it would have made a difference, who's to know, but I really don't think so.
Hard to second
It's
guess,
hard.
but I think
It
it would
is.
have like she's damned if she does and she's damned if she doesn't, right? Thank you, Kathy, for your super sticker. Thank you, Sandy B. Karen's Google search is accurate, but Jen's isn't. Yeah. apparently. Check out Truth and Transparency, cleaned up 911 call. Thank you, John, for
They do a
that.
really, really good job, Truth and Transparency. She's, if I'm thinking of the right one, I think that's the one I'm thinking of. If it's a woman, Bob will kill me if he
So
watches
many
this.
channels.
How
Candy,
do you
thanks
not
for
know this person by now? We are always talking about them, like something
Oh,
like
because
that.
you don't have a million other things in your head, being a mother and a, grandmother now, and a million other things swirling through your brain that sometimes the minutia gets lost in all there, at least for me. Tanny, thank you for the 5. I've tried to think through alternatives, but I have to think about Lucky's testimony. No body, injuries to his face. How?
I
I
mean,
mean,
the
the
only thing you
temporal
can,
lobes being smashed in, and
the
the
only
frontal lobe being smashed in, and the brain swelling, and
the only thing you can think is that it's possible that he was waved to a side door and he went around the back and to the side, and whatever transpired, everyone in the house might not have seen. And then he was on the side until eventually he was brought out.
Tell them the
And
guy never went in the house. Maybe he didn't go in the house. Maybe he went to take a leak in the backyard. We don't know. Maybe he smashed his head on the concrete back there. We don't know.
And that's why I'm so big on, because the jurors had to be tossing around their own possibilities back there,
Mhm.
that the closing should have involved some part of, you guys use your own discretion. Don't listen to me. Don't listen to Lally. Think about it yourselves. But for every other possibility you come up with, that's reasonable doubt.
That's such a great closing argument, Allie. Maybe they should bring you on the team. Thanks, Deb. Yeah, says we make a great team. Thank you both. Thank you, Deb. Thank you so
Thanks, Deb.
much. Sandy B. Wolf said the damage that they saw of the taillight after it was Proctor.
I agree. I absolutely agree. He was not talking about a crack. So but the point is that there are clearly some people on the jury who none of that stuff mattered to. So fine, let them lay their hat on. Maybe that stuff was there because he threw it at the taillight, because clearly they're ignoring every other thing anyway. If they're
Mhm.
getting to the point that the car touched the body, if they're getting to that point, they're ignoring all the things that we think are obvious. So
Right.
give them something to lay their hats on, even though it doesn't make sense with all of the rest of the evidence. But at least it's an alternative that doesn't require them accepting everything the defense says versus everything that the Commonwealth said. But I 100% agree. Sandy B.
Sandy B. Tracy says, my company uses health data for an insurance discount. Can you tell me how I can make it look like I'm walking upstairs and walking while I'm in the car?
Right.
I mean, either data lies or it doesn't. Like, they're going to have a big problem in some other cases that they've got there. Lindsay
Melanie, can you tell
Clancy.
me this? Everyone else did that same drive. Everyone else did that same drive. Why didn't we just compare one other person's phone and see, did it show they went up and down stairs? You had Karen Reed's phone. Why
Mhm.
didn't the defense even point that out? Did Karen Reed's phone register the same up and down stairs when her phone traveled over the same exact path that, and all of the whole everybody there went through that same path. Show me on anyone else's phone in the whole damn world that
That's
you
right.
can have someone going up and down stairs when they go over a hill. I think that I've looked at it before and might have tried that because, like when you're like doing your steps and you're exercising, like, well, what does it exactly register? You can't just trick the phone.
Yeah, right, right. I mean, there's no Stairmaster in the back of the Lexus, and the hill. Like, really, we're gonna go with the hill now. I mean, it just seems like, I don't know. You can't physics. It's physics. Karen from Canada, Allie, any relation to Judge Motta in Arizona?
Not that I know of it. That would be my husband's family, but I don't think so.
Hmm. Kyle says complete speculation. John O'Keefe is Serpico 2.0. An FBI. Thanks, Kyle. Entry required. Thank you for popping in here from, I think, Sweden. Look up potato can. Non-kids do this. No tech fee. I don't know what that. Can you decipher that?
Look up potato
Potato
can.
can?
Non-kids can do this. I think he's saying, like, even that this tech is no feat, like the whole faking of alive, like even a kid could do that.
Oh, we're talking about going back to the Karen
I
Allen
think so,
photo.
yeah.
Gringa, any confirmation of whether John O'Keefe's brother smiled at and or spoke to Karen Reed in the court after the jury hung? I think he said something to her like, "We're not done with you yet." That's
I don't know about smiled. I
Yeah,
saw
I don't think he
something
smiled.
not pleasant.
It was not pleasant, and her look was not pleasant. Gay Lynn gifting 10 memberships. Thank you, honey. Thank
Very
you so much.
generous.
Haven't seen you in a while, Galen. I
Potato
hope you're doing
cannon.
well.
Somebody resolved that was potato
Oh, the
cannon.
potato famine. Sankota says that you ladies are awesome to listen to while at work. Thanks for making my day not boring.
Thank you.
Hashtag WVU.
What's that mean?
West Virginia University? I don't know. Is it? Do you have any connection with WVU? I don't know. I mean, if that's what it is.
I
I'm
thought it
not
was
sure.
like something hip that the kids use that.
I'm like, can you translate for this for me? Just me. Wonder if the feds were looking into trafficking. Happens a lot at sports stadiums, Foxborough, other arrests for it around there. Tara, defense was sending DNA for testing. Did that ever come? Yeah, the Bodie Lab stuff. That was the Bodie Lab stuff that came during the trial about the hair. Precariously placed hair. 5 different sources on his jeans. Everyone in the house should have given samples, or did they? No, they didn't.
No,
They had
only.
so much trouble on these Rule 17 motions getting third-party discovery, pretrial in this case.
Oh, they did do a lot. The judge shut them down every way.
Yeah, they had to go to the appeals court to get Jen McCabe's Google search records from her carrier. Went up on appeal to get Brian
Wow.
Albert's cell phone records. I mean,
I don't think
and a
we
lot of it
could
was shut
even.
down.
I don't think if it was Illinois, we'd be allowed to do. You can't do an interlocutory appeal on just anything. If you're on the defense side, and the state can do it. Like if you win a suppression motion and like a huge chunk of evidence is out, otherwise you got to wait till the end. Which is one of the things they should really change when they're looking at criminal justice reform, because it's so unfair to say the system works so well. Let's just wait and make sure you're found guilty before you come back and try to fix things.
Right. Right.
Spend your
But
life
in
in
fact, what do
prison
you think
waiting.
about the other sources of DNA on and that was testified to at the trial, on his jeans and on his shirt, that there were some of the stains, which I assume were blood, had like 2 unknown contributors, some had 3.
I wonder if they looked at the mitochondrial to see if they were 2 men of the same family, they would have been the same.
I don't even know that they went that far. Oh, here's somebody. Lisa Lang loves you. Love
Oh,
Allie.
thanks, Lisa.
Terrena Turtle Boy did it before assault. Did what? I'm not sure. Did you see the dash cam with Lucky passing the scene? No, I haven't really looked into that
Yes,
file.
I think they might have put that up at closing or at some or more. Maybe it was during his testimony. I do remember that they're showing the cars, the police cars at the scene, and you see a snowplow up ahead. So if you're standing on the street and the Albert's house is to your left, it was crossing the cross street just ahead. If that's what Kyle's talking about,
I think that's what he's talking about. Yeah.
but I wonder what
I
he
mean,
thinks it shows. I think just that Lucky was there around the times he's been saying that he was there.
right.
Right.
And that because he said he went by and the street was closed off.
Yep.
My phone GPS says I'm at the end of my driveway right now. I'm in the house and my room says summer.
Right.
Yeah. I mean, there's a radius, right? How could
Right.
the
And when
guilt-
they tried to say it wasn't moving from that radius, it's putting you in the middle of a radius. So unless you go out of that radius, I don't think it's gonna necessarily move. Just like she's saying, like says she's in the driveway. Well, how far does she have to go before it says she's on the sidewalk or now in the house? Like it could keep her in the driveway while she's walking around, or he is walking around in the house.
Right. Yeah. Vinny Politan has his own channel on Court TV on YouTube. If everyone could please subscribe to my channel right now, it's free. I'm in an
Yes.
unofficial competition with Vinny Politan to get more subscribers than he does. And
Well, I
right now
want
I
to be
have
in this unofficial competition. Subscribe to Defense Diaries podcast too.
that too. Yeah, I'm going to definitely put that. But Vinny has, I don't know how many subs, but I think I'm up to 59,000.3. So Vinny was on his own channel last night screaming about, why didn't they get the cell phone data from everyone in that house? Why didn't they get the geofence data to prove who was in that house? And what Vinny doesn't know is they did try to get it. But when Proctor put in his request, he only put it in for Android phone users, not iPhone users. And, was it an intentional gaffe on his part? Probably. But Vinny, you don't know how many hoops the defense had to jump through to get third-party discovery in this case. The judge was not allowing any of it. And now Vinny is saying, well, if the prosecution is going to say that none of these people did it, they should get the cell phone data from all the people that were in the house to show when they
too late.
left. And
I think it's too late for just the satellites. I don't know that they hold because I don't know that they hold that information, and a lot of those people got rid of their phones. But if
right.
there's a competition, apparently since Melanie had paid attention to all the pretrial motions, so she knows all the hoops they jumped through, she should
Hmm.
win this competition. So subscribe.
Right. So subscribe. It's free. Hit that button. There's a new YouTube format, which I'm not a fan of. And sometimes now I think you have to close out the chat to like the video to subscribe. I don't like it. I think they
That's what
should.
I've always had to do on my phone. I'm
Oh,
always telling
really?
people, yeah. So for example, let's see what you got right now because I do this
Like, for
on
example, it says
my
right now
lives
that
right now.
this video is already published, but it's still live. Like it says 16 hours ago. And like, I can't even click on, like, it's just, I don't like it.
So, and I'm looking at the one that we're on right now. There are 60, there are,
6,286
and
people
only
watching.
2.8 thumbs up. So if you haven't thumbs up, you've got to minimize the chat. We'll pause for you to do so.
Yes, you
And
will. We'll
click that
pause.
thumbs up and then we'll watch. We'll see how it goes up from
We could put the
2.8.
fan on. Let everyone watch the fan for a little. Yeah, Vinny's up to 69,000 subscribers, and I'm at, what did I just say? 59. So I need 10,000 more people because I'm in an unofficial competition.
All right, I need about 40 more to get near you guys, I think. So
come on, everybody, go hit the thumbs up on Defense Diaries. I'll come on anytime you want, Allie. And now that you feel
Sure.
comfortable hosting, I think. William, thank you. How could guilty jurors get past the arm injury? I don't know. That's what sealed the deal for me.
There's some uniform injuries there. It's how and it just I just don't, and they never explained it. Even if you believe everything Trooper Paul said, he said that the unbroken taillight hit, he says the shoulder, but at some point he also said the glass in the hand. So I don't know. And then continued past the body and scratched him all in those different places in different ways.
Right.
It just doesn't make any sense. And that's what I wish that that they would have drilled home in that closing. Every time something doesn't make sense to you, that's reasonable doubt. Every time, like the Commonwealth presented one theory. That's the theory.
Mhm.
That's the one that they have to prove to you. Not if you're back there thinking it could have happened a different way.
Yeah.
Or if you're questioning, could it have happened?
Yes. That's reasonable doubt right there. Stop.
That's
Don't go
reasonable doubt. Right.
You're
Stop.
doubting. Nancy, only 1 hour for close. Yet Lally can call 7 million witnesses and drone on forever just to confuse. Not fair. Thank you, Nancy. Well, the defense could have called as many witnesses as they wanted to. I think they just wanted to, knew the jury they were losing the jury and it was
I
too
think they sent
much.
I thought they sent a very strong message of how, okay, like this is how we're telling you all of this quick, concise. What did you get over there?
That's how it should be done. Scott, thanks for the 10. Melanie, thanks so much for your coverage of this case. It was great to meet you. It was great to meet you too, Scott McGinnis. It's always good to put the faces with the names. Getting my picture with you and you signed my sign. Awesome. Mark Betterow too that day. Thanks, Scott. I did. I signed your sign. I said, give me a Sharpie. I want to sign this sign too.
There you go.
Thank you. Why wasn't the original 911 call played in the trial? The Gamer Burger wants to know.
Was it not?
No, they had the only one they played was the one where Karen had dropped her phone in the back seat.
That's interesting because 911 calls start recording before they connect. So
Yeah.
I was surprised because when I thought I was hearing the 911 call, I thought it was the real 911 call. And I was like,
right.
They're perfectly quiet before they answer. That's like a huge tell. If like there's all of a sudden it's quiet and then they get on and you're like, oh yeah, and it's like, well, wait a minute. We were recording for 10 seconds before this and you were quiet. So that's very strange. Are we sure that they didn't play the real 911 tape?
I don't think that they did.
That is very odd.
Did they have it to bring back with them in the jury room? Nothing records in Canton's at KBT. And it was like, they played both, somebody said, mistrial. Did they?
Well,
Where
then
she said, yeah. And she said, yeah, because I remember, these are me and passed out in the snow. Come, send somebody to 34 Fairview. She never said, come to, I'm at my sister's house. There's a man dead on the lawn. Police officer down. Never said he's a police officer. It was distancing language.
If the one I heard was the real one, she was dead quiet. It wasn't even like, like sadness in her voice before connection.
And then she got transferred because she went to dispatch like somewhere else because it was a cell phone call. So I can't confirm or deny Turtle Boy terrorist says Turtle Boy did the driving test for the steps. Oh yeah, he went down the hill in his car and it didn't record him doing any steps. Lally changed his times. The video proves him. Yeah, in his opening it was 12:45. In his closing it was 12:30.
And that's
But
another thing that I would have focused on the in my closing as the defense. Like, why did they tell? They've been telling you. How many times do you recall the Commonwealth telling you that this happened at 12:45?
How did he not know his own evidence?
I mean, he
Going
really
in there.
didn't though. He really didn't though. I mean, I don't think it was all a show. I think he honestly didn't because he asked, if you recall, and you and I talked about it. Hi, Joe Schmo,
Thanks, Joe
on
Schmo.
the live that we did before when he had the taillight woman who put it all together. He asked on those bags that represents the date of the collection, right? That's why I assumed it represented the date of collection when we first talked about this. Then afterwards, went back and looked and confirmed there's a picture in the search stuff of something collected on 129, and I had to put I put a comment in your live saying, that's not the collection date. Even, it was, according to pictures, looks like collected on 129. But he didn't know that. It's the hugest part of his evidence. It's the hugest part of his case. This was here on 129. There wasn't enough time. And he asks his own expert, but the date on this bag demonstrates the collection time, right? I mean, her answer was, I would assume so, but it's not my office doesn't fill that out. We have nothing to do with it. It's somebody else's date. But no, it didn't have to do with that.
That's right. Nobody had any ring camera footage of the incident.
One
The
guy
whole thing
did.
was weird. There's
the incident.
no of the incident, but they told the media right away that they did.
Yeah,
Aaron.
and Buchanan said even if a bird flew by, that would have triggered the ring camera.
Yeah,
Like,
and the
we're
deputy
talking
chief
about
of Canton PD lived right across the street, and his camera didn't show anything, and he said it wasn't interesting. So nobody looked any further into that either.
It's crazy.
Since the jury can't reference testimony during deliberations, I think Lally bombarded them with witnesses, hoping the lack of proof would get lost, says Karen. That's a good point.
Yeah.
Suzanne, this was altered by somebody else's name I won't say on this show. It's been totally debunked by an happy 4th, Suzanne, and to everyone. And this is interesting too, sock girls, because I thought this too. They were told no transcript, i.e. full transcript, but didn't know they could ask for a readback. I don't know.
That's what I was wondering too, because that's different than a readback. And the
Right.
law, I can assure you
Confusing.
that the law says they can either have it read back or sent back in Massachusetts.
Elaine Nix, I saw a poster reportedly made by a member of the O'Keefe family that said something like, an innocent person doesn't celebrate a mistrial like guilty person does. It's sad. This whole thing is sad.
I have to remind people that it's really hard for the family. They're being told by people they're supposed to trust, police officers, the prosecutor, we've got it right. Trust us. We've got it right. I mean, this is what they're being told. So we can't fault them for putting their faith in that and believing it, if in fact they do, which it seems like they do.
Alistair Crowley, maybe you weren't here at the beginning. No, there are no readbacks in Massachusetts. Allie did the deep dive into the legal research of this, and it is at the judge's discretion, right?
Right. That's what the Supreme Court of Massachusetts said. And I checked. I actually have one of the cases up right now, but it needed me to sign back in. It was like I forget
I
what
believe
year
you.
if it posts up, but then I went and did some. It was a 2014 case, but then I looked at a 2022 case as well. So, but I understand what that viewer's saying, because what we've heard is that they don't do it.
They don't do it. But she preemptively said you're not going to get it. So
Right.
she sort of ruled on it before it became an issue.
Right, which as a matter of law shows she did not use her discretion. That's an abuse of discretion.
Yeah.
Because you clearly didn't use any discretion. You decided beforehand, and if it's supposed to be decided on, what's going on in the case, and I don't know, maybe there's something that says that the judge can have a strict policy, but when they go through the trouble of writing out very, going through everything to put a case together and to lay out the law, saying why they have discretion and, why they should have discretion, that
Right.
speaks to something more than just a blanket policy of no.
Right. Ashley hopes that Mark joins Karen's defense team as a consultant for the second trial. I'm sure he would if he was asked. Pastor Prime, thanks for the 5. Lally wrongly stated testimony during closing also. Yep.
That happens all the time.
Yeah. It's not evidence. They're not even supposed, they can't take notes during that. Gretchen B, 36. I never trusted Bev to do the lawful and just thing for this trial. Did anyone else see the jury forms? Yes. If you didn't see it, we did go over the jury forms at the beginning when Allie first came on. So rewind later and take a look at that. So Al, we've been at this for almost 3 hours, and I would thank you so much for coming to join me
You're
today. And if
welcome.
there's
You're welcome.
anything that you would like to say in closing, I can give you the whole screen if you like.
No, I think well, I mean, I guess I'll just say that if you want to catch me and my husband's also a lawyer, legal coverage on cases, we are a true crime podcast, and that's the YouTube station as well. We are Defense Diaries, but we do trial coverage with the shaming of Jay and alternate on his YouTube and our YouTube. He is the comedic relief. He's very smart. He's got a lot of court background, and he's the courtroom jester. I say he provides comedic relief, but again, he's also provides very intelligent layperson input. And then you've got a seasoned criminal defense attorneys going over everything as well. So a little different than your straight law tubing. But I hope to see you guys all there. Hopefully subscribe to both so you don't miss us. And if you like podcast, Defense Diaries podcast, my husband's father represented John Wayne Gacy. So the first season, it's not about Gacy himself, but it's about the investigation, the witnesses, and the trial. And his father recorded pre-trial interviews with John Wayne Gacy. And that's how the whole Gacy tapes series came together. Although it did not involve our tapes, my husband had taken it to the producer. It was going to involve his tapes at first, but he didn't like the way they were going. We also covered the Lori Vallow trial on the podcast. And right now we're covering a serial killer case that my husband and I both handled out of Nebraska with Dr. Anthony Garcia. And that's going on now. So if you like us, follow us, and definitely subscribe to our YouTube channel. I'd love to get in on this battle with Melanie.
Competition.
I'm pretty far behind. We're pretty far behind. We got like 22,000.
It can happen fast. What's the next trial you're going to cover live?
I guess it's what's his name? Alec Baldwin.
Oh, you're going to do Alec Baldwin? I may do the Black Swan. I'm waiting for my
Bob
viewers to
talked
vote.
about that as well. Maybe he should take a vote.
No, let's do different ones so that everyone can watch everyone, right?
There you go. But Bob and I were just talking about covering the pre-trial motion to dismiss for Alec Baldwin before the trial, because to me, I just don't get it. I don't get the criminal intent in this scenario. But
I'm also an actor, so I'm like, listen, if an armorer who is hired specifically to make sure there are cold guns on set hands me a gun, and the director says, please point the gun right at me, I don't know, civil liability, sure. Wrongful death cases up the wazoo.
Right.
But the criminal intent, I have a hard time with it, and I haven't done a deep dive into it. So don't anybody trash me in the comments yet.
Right. I haven't done a deep dive into it either, but my initial legal instinct is I see issues. And by the way, when we asked your wonderful viewers to minimize the chat and give the thumbs up, you got 1,000 more thumbs up.
Yay. Everyone,
you
more
guys
thumbs
are
up.
The greatest. Give yourselves a round of applause.
Minimize it. Oh, wait, we have like 50% thumbs up. That's amazing.
That's
for
great.
6,000 viewers over 3,300. So that's a great ratio. YouTube loves analytics. They give you more analytics than you even know what to do with. eMurph42 says, in Colorado, juries can ask questions of every witness. I wish so very much they could.
You got one more one more super sticker that
one more.
Just came in.
But wait, I went to law school in Colorado, so I am a buff. Go Buffs. Boulder strong. Love Boulder. I went to University of Denver Law School. So yeah.
Did you practice there at all? Because it's fascinating to me when jurors can ask questions. Did you practice there at all?
I did not. I left New York, and I left Colorado and came back to New York to take the bar. So I did not. I mean, I practiced in the student law office. I represented clients in court, as part of my law school training and supervised by a law school professor. But it is fascinating. Is this the one you're looking for? Well hung jury. Oh, I love when they change their names to match the trial. Well hung jury. I see what you did there. I don't know why people find Karen so off-putting. I really feel she's being judged because she didn't want children. Isn't that self-awareness?
And I agree. I don't know why I know I mentioned that as one of the reasons maybe don't put her on the stand, but it's not because I think that she is off-putting, but you've got to, and women are judged way harsher than men. And the one
Mhm.
case I was talking about, that was a guy on the stand. And with them already having people in the public every time she moves or blinks or does something like, saying she's off, finding issue, that's why I was saying. But yeah, you're absolutely right. Well hung jury.
And it's women that are tearing down other women, mostly on the cesspool of Twitter. If you notice that, people do not like successful women. She had a great career. She made a lot of money. I don't know if she's working right now. She's very successful, very smart, single woman who did not need to be tethered to a man to survive financially. And I don't know why people like to tear down other women. I find there's a special place in hell
Yeah.
for women who do not help other women and instead try and tear them down based on their looks or success or anything else. Jealousy. I don't know. Coincidence that strongest not guilty jurors eliminated, says Z. I don't know. We'll never know.
Never know.
All right. Hang out for one more second backstage, Allie, if you don't mind. Say
All right,
goodbye to
will do.
Allie. And
Bye,
just
guys.
give me 1 sec. Thank you, everyone, for coming and spending 3 hours with me this morning. We're all getting withdrawal from not covering this trial, but so happy that Allie was able to join. Please go sub up to Defense Diaries and to Asget Industries, who let us play her video, as well as Truth Revealed on YouTube. And remember, my friends, I'll be back to see you soon. Let me know what trial you want to cover live next in the comments. Come for me in the comments, not on the cesspool of Twitter, in the comments here on this video. Hit the like button, hit the subscribe. Thank you, moderators, for keeping the chat classy as always. Go take a listen to the Karen Reed playlist. I think you're going to like it. And as I always say to close out every stream, be cool, be kind, be classy. Really, it is not hard. It is so not hard. Thank you for hanging in, and I'll see you again real soon. Hit the subscribe and the bell so you'll know, because I don't have a schedule. I just kind of come on when I want. Peace, everyone. See you soon.